If you've been watching my recent videos, you will have noticed that the content of my videos have taken a turn toward, for lack of a better word, the macabre. I've been covering serial killers and hybristophilia and psychopathy and the causes of these phenomena for quite some time now. Now, I don't know how ill or well received these topics are in comparison to previous content, but I do know why I've been focusing on them. I am of the opinion that in the worst of humanity, there can be found clues about the fundamental state of the human condition. I believe that in these boogeymen, these killers and rapists and psychopathic individuals, the truths that we have buried, that have motivated the Aztecs to rejoice at the removal of human hearts from the chest cavity of their prisoners, the Salem witch trials, the lynchings, the killings, the burnings at the stakes that unfolded throughout history, can be explained. I'm not a consumer of the macabre for the simple act of curious consumption. I consume with a purpose. There is a limit to how much of this stuff I can stomach. There are individuals so vile and so cruel that I simply must turn away in disgust and allow myself a break from it all. I remember the case of Lawrence Bittaker and Roy Norris and what they did to their victims, and the few seconds that exist online of audio of one of their victims' torture and murder at the hands of Bittaker and Norris. That was enough to keep me far away from this stuff for a long, long time. I couldn't sleep. I was legitimately traumatized. And when researching this kind of stuff, you feel the slow creep of misanthropy and hatred of the human race for man's inhumanity toward man taking hold. And, frankly, I had to back away a little bit. I don't want to view things of this nature and then lose my empathy for humanity. That's not my purpose. My purpose is, in fact, the exact opposite of this. I want to see the worst of humanity and still have empathy and still attempt to understand. I sincerely believe that the major problem in our world today is that too many people refuse to put themselves in the shoes of the other. And more importantly, and what the topic of this video will kind of be about, I believe that the further away another human being is from our identity, the way we view ourselves, the less likely we are to empathize with them, which is why I consider myself a staunch death penalty abolitionist, and I'll explain why in a little bit. But before we enter the debate about the death penalty as we know it, that is, the execution of a person after being duly convicted of a capital crime by the state, I think it important to first state that there are in fact lesser discussed, but just as deadly forms of capital punishment which either exclusively target men or overwhelmingly target them. Those being the draft, which is a form of state-sanctioned enslavement and murder of men, and also there are the many ways in which society creates social norms where men are exposed to situations in which they are bound to face their violent demise. One of these being the way we expose men to a disproportionate amount of vigilante justice and rejoice in the rape and murder of men in our prison systems. Thus, this video will attempt to address three core issues, which are a discussion of implied capital punishment, or unofficial forms of capital punishment, a discussion of gender bias in the justice system, and a discussion of the immorality of state-sanctioned executions for capital crimes. At times, these issues will blend into one another and overlap, and I will sometimes go from discussing, for example, implied capital punishment to criminal justice bias in general, so apologies ahead of time for any confusion this may cause. First off, I wish to share with you a few cases of men who were innocent, but were killed by vigilante mobs. Sebastian Judalet, a 38-year-old Frenchman, was vacationing on the island of Madagascar when a group of about 100 locals confronted him and accused him of being a pedophile who murdered and mutilated a local 8-year-old boy. Tragically, although Judalet vehemently denied doing it, and although there was zero evidence against him, he was stripped naked and burned alive without a trial. Somewhere, floating around on the internet, if you really want to listen to it, are Sebastian Judalet's last words before he was murdered, but I refuse to play it here on both a moral ground and frankly because I think it would invite flagging for breaching YouTube policy on graphic content. I know the first instinct is to suggest that this is a tragedy that was somehow a result of the backwards attitudes of the nation of Madagascar, but I assure you this happens right here in America and in the UK and in Germany and Australia, etc. This is something that absolutely happens in the West all the time. Bijan Ebrahimi was murdered in the UK for taking pictures of children, vandalizing his garden, and was wrongly accused of taking pictures of minors for the purposes of child porn and pedophilia. Now, police initially arrested Ebrahimi, and a crowd of neighbors assembled and chanted pedo over and over again while they were taking him into custody in his home. Police then conducted an investigation and confirmed that Ebrahimi was simply trying to catch the children who were vandalizing his property in the act. He was let go and was not charged with any crime. This, however, was not good enough for the vigilantes, whom had apparently made up their minds about his guilt when he was initially arrested, and 2 days later, one of his neighbors, Lee James, and his friend Stephen Morley beat him unconscious and then burned him to death and left his body to be discovered on the side of the road. Brian Davies was a retired auto mechanic who tragically suffered a heart attack and died after prolonged harassment for being falsely accused of inappropriately touching 2 young girls who lived in the neighborhood he had just recently moved to. Davies and his wife had befriended the girls and allowed them to walk their dogs, but after one of the girls asked if she could sleep overnight at the Davies home, Brian Davies rightly deemed that to be inappropriate and refused. Shortly after that, the 2 girls made false claims that Davies inappropriately touched them and exposed himself to them. Police investigated and found no evidence that he did anything of the sort, but he was the subject of constant harassment anyway. He was obviously not believed by the family of his accusers, and Davies suffered a stroke because of a targeted campaign against him. Now, after this, in what is in my opinion a very rare step from a police department, the police actually distributed flyers around his town stating, quote, "Attention residents, there have been allegations made about a local resident paying inappropriate attention to young children in the area. The result of our investigation is that the allegations have been found to be false and without foundation whatsoever." Now, shortly after that, the Davies moved to try to escape the constant barrage of false accusation and harassment, but the rumors followed them, and shortly after that, Davies was hospitalized again after his initial stroke, and unfortunately died in the hospital after suffering a heart attack. Brian's wife, Debbie, made his funeral procession drive by the home of the 2 girls who falsely accused him in the hope that they would see what the end result of their actions were. Christopher Hunniset, a vigilante murderer and self-styled pedophile hunter, was arrested and convicted of murdering and dismembering Reverend Ronald Glazebrook in 2001. He served 7 years in prison for that conviction, after which a retrial occurred and Hunniset claimed that Glazebrook had molested him at the age of 12. He also claimed that he did not in fact murder Glazebrook, and his conviction was overturned, and he was cleared of all charges and set free. 4 short months later, Hunniset, then aged 27, brutally murdered Peter Bick, a gay man who had absolutely zero history of pedophilia whatsoever and was deemed completely innocent of any crimes against children, but Hunniset still decided to put him on his judge, jury, and executioner hit list, which numbered no less than 900 persons. Hunniset lured Bick for sex before bludgeoning him to death with a hammer, and then proceeded to send false texts from his phone after killing him to make it appear as though Bick was knowingly going to meet with a 15-year-old boy to have sex with him. So not only did he falsely accuse a man of pedophilia, he murdered him and then staged evidence to make it look like he had in fact meant to meet up with a minor for sex. The infamous and horrific Snowtown murders are one of the worst cases of pedophile hysteria and vigilantism in modern history. This was a case where perpetrator John Bunting and a few others he manipulated into believing that the majority of his victims were actually pedophile homosexuals, murdered 11 people, most of which were simply homosexual with absolutely zero evidence of sexual abuse against children whatsoever. The few cases where his victims did have evidence of pedophilia against them were extremely flimsy at best, but it really wouldn't have mattered since Bunting also believed that homosexuality eventually leads to pedophilia anyway. Now, the depravity of his crimes against his victims are literally so vile that you would expect them from a bad slasher B movie, not actual real life. A link is in the description if you're willing to go down that particular rabbit hole. I'm not going to do so here because, again, it may get this video pulled for violating YouTube rules against graphic content, but needless to say, it is bad and likely one of the worst examples of vigilante justice murder I've come across. So yes, there exists plenty of examples in the supposedly civilized West of vigilantes committing brutal murders against innocent men, and we all know that these vigilantes, whom are disproportionately men, will visit this vigilante justice disproportionately on, you guessed it, other men. We have countless examples of female teachers molesting young boys, in many cases admitted examples, so not even ostensibly innocent, but actual female child molesters. But you'll have a heck of a time finding instances when these vigilantes brutally murder female sex offenders like this. And that is because society deems men more criminal simply for being men, and also believes, and this is important, not only that it's okay to take less precaution regarding due process and innocent men, but also that men whom actually are criminal are more deserving of violent retribution than women who commit the same crimes. Again, this is a hugely important distinction to make. This video is not just going to be about how men are more likely to be executed after a trial, but how crime and punishment expects a higher standard of punishment for men who commit crime in general. Before we get into that, though, I wish to also discuss prison suicide as a form of de facto capital punishment. The fact is that, unfortunately, some of our prison systems are so hellish and so devoid of mental health services that prisoners, whom are of course disproportionately men, are killing themselves to avoid the serial rape and violence that is routinely a part of prison life. I want to cite a Department of Justice accounting on prison mortality showing state prisoner deaths between 2001 and 2014 by cause and by gender that documented 45,650 total deaths, of which a staggering 43,562 were men, and out of these total deaths, 2,826 were suicides. And of these suicides, only 150 of them were women, leaving 2,675 suicide deaths for men. And again, of the total 45,650 deaths, 845 of them were due to homicide. Of these 845, only 4 were women. So you would think that with these extremely lopsided statistics, no one would be making jokes about how men are going to be raped or beaten or even killed in prison, but the exact opposite is the case. I have never once in my life heard a person make a joke about a woman being raped in prison. You don't ever hear jokes about Casey Anthony being raped, but you will hear jokes about O.J. Simpson being raped, even though they committed arguably equally vile crimes. In fact, male prison rape and sexual assault is so rampant and unpunished in our prison systems that it should be considered a public safety and health crisis, but because they're criminals, and because we insist on being quote-unquote tough on crime, and because they are men, we ignore it. There are no Me Too hashtags for these men. There is no testifying before Congress for these men. They are just quietly told to deal with it, or it's swept under the rug until they kill themselves. There are also men whom are too scared to kill themselves, who wish to die, and commit capital crimes in hope of getting the death penalty, which we're going to discuss later, possibly in an addendum to this video. This video is going to be so large, but it still doesn't fully cover what I want to talk about here. But for now, I want to share with you an article I read by Christopher Glaze titled, quote, "Raise the Crime Rate," and I just wanted to share with you this passage. Before last year, the federal government had never bothered to estimate the actual number of rapes that occur in prisons. Its data relied on official complaints filed by prisoners, which in recent years have averaged around 800. One such complaint was filed in 1995 by Rodney Hewlin, a boy from Amarillo, Texas, who had been arrested as a 15-year-old after throwing a Molotov cocktail into a pile of garbage. The trash burned, causing about $500 worth of damage to the exterior of an adjacent house. Hewlin's prank was unimpressive, but Texas in the mid-90s had little tolerance for teenage ruffianism. In 1994, George W. Bush had become governor, defeating Ann Richards, a popular incumbent, by depicting her as soft on crime. Hewlin was charged with 2 counts of second-degree arson. He was a small guy, just 5 feet tall and 125 pounds, but he got a big sentence, 8 years in adult prison. Within a month of arriving at Clemens Unit, a temporary holding facility outside Houston for juveniles on the way to adult prison, Hewlin was raped by another inmate. He asked to be moved out of harm's way, but his request was denied and the rapes continued. In a letter to prison authorities, he wrote, quote, "I might die at any minute. Please, sir, help me," end quote. Help was not forthcoming. Getting raped was not deemed urgent enough to meet the requirements of the prison's emergency grievance criteria. When Hewlin got his mother to complain to the prison's warden, she was told that Hewlin needed to, quote, grow up and, quote, learn to deal with it, end quote. Hewlin's method for dealing with it was to kill himself. 10 weeks after his arrival, he was discovered dangling from the ceiling of his cell. Hewlin's case was unusual. Most prisoners who get raped do not write letters to the warden. It isn't hard to see why. Resisting an inmate who claims your body as his own, or worse, acquiring a reputation as a, quote, snitch, can turn an isolated incident into months of serial gang rape. And that passage, gentlemen, really hits home. I mean, being a victim of rape in prison is not the unusual occurrence. It is instead men even daring to come forward to name their abusers that is rare. And unlike Hollywood celebrities, These people can't leave jail to avoid rape. They can't afford to hire security to protect them. I know there's been a lot of controversy with the whole Harvey Weinstein case, where some of these accusers willingly continued to carry on a relationship with him after they alleged that he raped them. And that certainly is possible. I mean, that can and does happen. So I'll withhold judgment of both Weinstein and his accusers until after he receives his day in court. However, these men in prison being raped aren't voluntarily spending time with their rapists, and they can't afford to be labeled a snitch, because in many cases it condemns them to even more rape. These men don't have an option of not associating with their rapists. So there are an untold number of men, and in some cases boys, because remember, this last example was 15 years old, who are literally being sentenced to death in everything but name in our prison systems. They're being left to rot after being raped repeatedly and given no legal recourse, no protection, and no empathy, and told literally to just man up and deal with it. And it is all done by people who draw a paycheck from the taxpayer to house prisoners. The suicide rate will undoubtedly rise for people who have been raped and have no legal recourse to put a stop to it. So I don't want to attempt to give you a definite number for how many men are being raped in our prison systems, because the truth is that there's so little empathy and action on this subject that we don't really know. But suffice it to say, it's almost certainly a number, whatever it is, that represents a massive human tragedy and a massive moral failing embedded in a very dark and unexplored societal blind spot. Again, we simply do not know how many men are raped each year in American prisons, but many people are, I think rightly so, forwarding the idea that America is possibly one of the first nations in which more men than women are victims of rape. We will never know, of course, until a complete overhaul of prisoner safety policies are enacted, but the fact that men kill themselves at such a disproportionately high level in prison compared to females gives you a bit of a macabre and disturbing insight into the cruelty of the modern American prison systems and how they disproportionately harm men. Feminists, who will often become enraged at the mere suggestion that women should avoid certain high crime areas after dark when genuinely concerned officers who only want to see no harm come to them suggest such a thing, scream that they're blaming the victim. This is what inspired, as you guys know, the slut walks. However, when we bring up this human tragedy of male rape in the prison systems, they say that it is the fault of men that men are being raped, the fault of toxic masculinity as a whole, or the patriarchy, or some other such canard. Even when men get raped, they still blame men as a whole for it. Lesbian couples have some of the most highest rates of domestic violence, yet you'll never ever hear any of these feminists, or anybody for that matter, blaming all of womandom for this. You'll never hear the matriarchy being blamed for the astronomical amount of violence that occurs amongst same-sex female relationships. And that is because the empathy gap is real in the difference in how we treat male and female prisoners. Ask yourself if you can see an example like this happening to a woman. A Portland man named Jed Myers was assaulted by inmates in a Yamhill County jail. There was an initial medical check, which, as you'll see, meant nothing, and Myers was then put in a medical isolation cell. After that, he lay in a cell with visible injuries recorded by the camera in his cell, clutching at his side and calling for medical attention 19 times over a period of 5 hours, where he succumbed to his injuries shortly after. He died of blunt force abdominal trauma. Now, this is the type of stuff that happens in American prisons. Do people die from negligence like this every day in American prisoners? Perhaps not, but it certainly happens often enough. And another point is that men are also raped without receiving medical and legal attention. Now think about that for a second. There is a culture that discourages snitching in prisons. Men are also less likely to report their rapes due to the fact that they are conditioned to think that any admission of being victimized is an attack on or a signal of faltering masculinity. Thus, rape kits are, in many cases, never administered. STD testing, which should be mandatory in prison, is never conducted. So their diseases are just allowed to progress and spread because they do not get medical treatment. And this is the reality of the United States prison system. And yes, by the way, anyone who considers themselves the moral and legal authority when it comes to imprisoning other human beings has a 100% obligation to provide medical care and safety to the people it imprisons. If you exercise a monopoly on violence and you imprison others, you then become responsible for their safety and care, and you become responsible for feeding them. They are in your custody, and you are required to provide them with basic necessities like food, shelter, appropriate medical care and safety. It's that simple. And the fact is that the United States is doing an abysmal job of it, and men are being raped, murdered, or killing themselves at rates that are simply tragic and unacceptable. So, now that we have discussed the unofficial ways in which our prison system kills innocent men, or, for lack of a better word, pretty much sentences them to death without actually killing them, we're going to now discuss a case where a man actually did commit a crime, but was grossly overpunished by vigilante justice. And that is the case of the murder of William Elliot. Again, I want to stress to you that there is a court of public opinion in which these vigilantes operate and an institutionalized legal system which also is more lenient on women, despite keeping in mind that the Constitution protects against excessive bail, fines, and cruel and unusual punishment for crimes committed. Stephen Marshall used the sex offender registry in Maine to locate the residences of and then kill 2 people on the sex offender registry. One of them was most certainly on the register for some pretty heinous acts of child rape and sexual assault. The other was William Elliot, who was put on the registry for being 19 and having sex with a 15-year-old. The reports indicated that had Elliot waited for a few months for the girl to turn 16, the relationship would have been 100% legal. Morally reprehensible? Perhaps, but legal. But even still, this is hardly a crime that warranted murder without a trial, or, even in my opinion, placement on the sex registry. There should be a legal dispensation allowed for when teenagers sleep with minors below the age of consent when the two are separated by less than 3 years. Give them probation or something, but to put them on a lifelong registry for essentially being horny teenagers is, in my opinion, absurd. And so, in these cases, as a society, we have to begin to ask ourselves whether or not it is an act of negligent homicide to put people like William Elliot on a sex offender registry with real, hardened, and dangerous sexual predators, when the likelihood is that Elliot was just a horny teenager that couldn't wait a few months to have sex with his girlfriend, who at the time was again months away from reaching the legal age of consent. I'm not saying it is right. I'm not saying that we don't have to respect age of consent laws. I'm not even saying that there shouldn't be some sort of legal consequence for what he did. I'm saying that we have a responsibility as a society to not provide a ready-made source of people for mentally ill vigilantes to target. And more importantly, even when the people killed by these vigilantes are the most vile, irredeemable child sexual predators you can imagine, we still have an obligation to make sure they aren't murdered by vigilantes acting as judge, jury, and executioner. They still deserve a day in court. That is not defending them. That is not child molestation apologia. That is just following due process, period. Now, one of the reasons for this is the fact that mentally unstable vigilantes are not interested in impartiality. They will kill who they want to kill, and that is informed by their own bias and prejudice. Thus, and this is my main issue with both vigilante justice and capital punishment, even those that are guilty of their crimes are being unevenly punished for characteristics that have nothing to do with the crimes they committed, and that is a profound injustice, even when it is applied to murderers and child rapists and anyone else. Now, if we take the case of William Elliot and compare it to, say, the huge amounts of adult middle-aged female teachers that are molesting students, some as young as 11 years old, who have been convicted and put on sex offender registries, we have to ask ourselves, how likely is it that one of these vigilantes are going to attack and kill one of those female sexual predators? The likelihood is extremely slim, and this is just taking into account the women that are actually put on the sexual offender registries. We all know there's a sentencing gap in favor of women that convicts women less on average and gives them more lenient sentences when they're convicted for the same crime as men. Therefore, women are doubly insulated from these types of retributive crimes at the hands of mentally unstable vigilantes. Not only are the vigilantes less likely to target them, but the law is going to put them on the sex offender registry less often for the same crimes. We all remember the case of Mary Kay Letourneau. This was a teacher who, while in her 30s, while married, started a sexual relationship with a then 12-year-old boy named Villy, I don't know if I'm pronouncing his last name right, Villy Feliu. She got herself pregnant, and I refuse to say that Villy impregnated her because the truth is that she raped him and used him to have his babies. she was initially arrested and was sentenced to a mere 6 months and not having to register as a sex offender, but was unable to stop raping Villy and was caught weeks after completing her initial jail sentence, raping Villy in a car again, while also having thousands of dollars in cash and a passport on her person. Doubtless, she planned to abscond to another country, possibly with Villy, so she's a child rapist and attempted child kidnapper. And this time she received 7 years, which is still an extremely light sentence for a serial child rapist who forced a teenage boy into parenthood who couldn't possibly consent to it. In fact, Letourneau and Villy are still together, so essentially Letourneau groomed a minor, in which their age difference spanned decades, to become her sperm donor for decades after their initial first sexual contact. Now, media outlet Seven Flagships did a mini documentary on their current life now, and there's an interesting part in it when the host interviewing them actually seriously presses Letourneau for an explanation for her actions, and he actually states that she was the adult and therefore the person responsible for her actions and the only person responsible, and in what can only be described as an incredible look into the psychology of a female sexual predator. Letourneau asked Villy over and over who was the boss back then, who was really in charge, trying to get him to say that he had the agency when he most certainly did not. Villy himself even looks flabbergasted and offended by the question, but she repeats it over and over, almost demanding that he take the blame for what happened. And Villy even states, he was the pursuer, and then there's a pregnant pause of awkward silence as if to say, but you were the adult. But she keeps asking him again and again who was the boss, and it really makes for some incredible footage. And I'm going to play only a little bit of it because copyright strikes and all that. I'll play a couple seconds of it, but you really should watch the entire documentary and get the full perspective here.
Visit Happily Ever After.
This is getting weird.
Who was the boss back then?
A world exclusive.
The entire exchange takes place somewhere between the 9-minute and 31 mark to the 11-minute and 17 mark. Later on, the clip shows Villy working as a builder's laborer, with the narrator stating that Villy once wanted to be a professional artist, but because of the mounting financial pressures of raising a family, he now works where he's at now, just a builder's laborer. The entire scene is just very sad and heartbreaking. And the fact that he's expected to provide for the children that Letourneau, who is again a child sex predator who raped him, inseminated herself, and bore his children, whom he now in adulthood is expected to provide for, is another incredible injustice entirely. But let's ask ourselves now, are any vigilantes going to track down Mary Kay Letourneau and murder her? I wouldn't want them to, of course. I'm not advocating for that, but I'm merely discussing what is the likelihood that it would happen to her. The likelihood is extremely small, of course, because she's female. And this is what I mean by de facto death penalty, right? Let's go back to the case of William Elliot, a 17-year-old who slept with a 15-year-old. Because he was a man, society found it acceptable that he was hunted down by a vigilante psychopath and murdered. But the only penalty for Mary Kay Letourneau is awkward interviews in which she has the nerve to state, like the narcissistic pedophile that she is, that the agency belonged to the boy she raped, not to her. And again, the way the interview closes out with him, working some home construction job to support his daughters, as though he should have any monetary responsibility for children that were made by this sick pedophile, turning him into a male broodmare at the age of 12. And this, my friends, is why I absolutely oppose the death penalty, because double standards like this are so real and so fucked up, and they don't end at the sex offender registry. They scale all the way up to capital crimes and capital punishment. To illustrate another example like this, let's look at the case of Emmett Till, the black teenage boy who was brutally tortured and murdered by a bunch of thug white knights at the behest of a woman, Carolyn Bryant, who falsely accused him of catcalling her and flirting with her. And then she admitted that she lied about Till's actions, and her husband and half-brother killed him to defend her honor. This illustrates perfectly the pitfalls of vigilante justice, and more importantly, how it is selectively applied in gynocentric and in this case racist fashion. Now that Carolyn Bryant has admitted she lied about Emmett Till, all these decades later, and essentially with her lies got him killed, what are the odds that this woman will be tracked down by some deranged vigilante and murdered herself? And again, I'm not advocating for this. I want to make it clear. But this is the problem. Vigilante justice not only kills innocents, but it kills only certain demographics that are guilty while sparing other demographics. And being okay with this is tantamount to saying that although individuals can commit the same crimes in this society, some of those individuals are guiltier than others just because we want them to be. Now, what does that tell us exactly? Well, any functioning society must have a way of making sure its citizens don't harm and victimize each other. And it has to set up systems and devote resources to structuring and maintaining such a system. In a way, we can look at this in the form of a cost, or a justice tax, if you will. No justice system is perfect. The scales of justice are depicted as such for a reason. Too much weight on one side can cause the scales of justice to tip too far to the other side, causing one demographic to have to bear an unequal burden in the payment of the cost of justice. And we can never fully remedy this. There will always be injustice unevenly applied in our society, but this is not an excuse for embracing fatalism. In a functioning and fair society, there must be constant striving to make the system of justice more fair, and a constant question of whether or not certain groups are being unfairly burdened with the cost of maintaining it. This means asking the uncomfortable questions and striving to never fall into the Orwellian pitfalls of some animals being more equal than others. And we, of course, cannot turn off our unconscious biases, so we have to develop systems of justice that attempt to circumvent these biases. And because of this, we have developed due process instead of vigilante justice. And because of this, I believe we will eventually develop the abolition of the death penalty in America, and eventually even in China and Saudi Arabia, the two countries responsible for the vast amount of executions. Now, I live in America, and thus I am much more likely to affect change regarding the issue of capital punishment here in my own country than I am in Saudi Arabia or Iran or China. So this video will focus more on capital punishment in the American justice system. I wish to make clear before I continue that I absolutely reject any notions of comparative fatalism regarding the astronomical amount of prisoners that, for example, China executes, a figure which is currently unknown exactly, but estimated to range into the thousands per year. The fact that many more executions happen in China is no excuse to simply give up on pursuing the abolition of the death penalty here in my own country, and I hope to persuade those watching to that position. There's a tendency for people who argue in bad faith that one shouldn't express regional grievances because somewhere out in the wider world there are worse problems. This is a tactic designed to foment complacency. America isn't perfect, but the only reason we have the standard of living we do today is because we weren't content with being told that we should tolerate things like child labor, for example, so we abolished it. It may have taken us a while and we weren't the first, but we did away with it. Or that employers couldn't toss us to the metaphorical scrap heap if we lost an arm toiling away in one of their factories. So we made that illegal, even though, many other countries hadn't yet. We enjoy the civil liberties and luxuries we have because Americans know it is important to never settle with not complaining simply because it's worse somewhere else. A smaller degree of a problem, in our eyes, is still a problem and still needs addressing, even if it is worse to varying degrees elsewhere. And of course, there are no varying degrees when dealing with an issue such as capital punishment. You're dealing with an infinite problem. One innocent life unjustly executed for a crime he didn't commit is infinitely too many. And one person executed for a crime he did commit, when another individual, a female, who committed the same crime would be spared because of gender or even race or any other characteristic, is an infinite injustice. Now, I also reject any claims that men should be expected to bear more of the burden as individuals for crime and punishment in our society because, on average, they commit more crime. I want to make my position clear from the start. The fact that one gender, or even one race, supposedly commits more crime in the aggregate does not and will never justify that an individual belonging to either of these demographics should in any way be given a harsher penalty for committing crimes. Bias, whether it be gendered or otherwise, can absolutely exist for a demographic that happens to commit more crime. And if you agree with this position, this will ultimately beg the question of whether or not the supposedly more violent group is in fact as violent as society claims they are. So, are men more violent than women? I think maybe overall they probably are, maybe. However, we don't really know, because the fact is that there are untold numbers of female child molesters or females who batter their husbands whom are never arrested, or who manage to get their husbands arrested due to the assumption that only men beat women. There are women who literally murder their husbands or their children and get away with it by claiming that they were battered or that they were suffering from postpartum depression. And more importantly, the women who aren't given a complete pussy pass for their dastardly deeds are very often convicted of lesser crimes for the same crimes that men get and are given much more time. So not only do women get off scot-free more often than men, but there is also a cumulative effect in the entire justice system. Women who are convicted get less penalty and as a result have an easier time re-entering and readjusting into society after they serve their time. And thus, at least some of the belief that men are inherently more violent is due to a self-fulfilling prophecy. Give men harsher sentences and more overall time, and you will see more recidivism and less reintegration into society. Women are more likely to murder their children than men are. And since male infants under the age of 1 are more likely to be killed by their parents, it very well may be a reasonable conclusion that mothers are more likely to kill their own children if they're male. But ask yourself, how many times have you heard statistics like these, as opposed to the cooked up, 1 in 4 women are raped statistics we hear repeatedly? And then ask yourself, what is the likely result of hearing a statistic over and over applied to only one demographic and almost never hearing a statistic applied to another in a negative fashion? What do you think that does to society's overall perception of that demographic? The fact remains, we are less likely to even hear about female violence and less likely to enforce harsh punishment when we do know about it. There is no, to my knowledge, gendered excuse for a male killing a child or a spouse. We do not hear words like, battered husband syndrome or testosterone overload syndrome, but we do hear things like battered wife syndrome or postpartum depression. It has been discovered that men with an XYY chromosomal makeup, or in other words, men with Klinefelter syndrome, comprise a disproportionate amount of prisoners in comparison with the general population and display an increased risk of committing certain violent sex crimes. But can you think of even one case where a man got off of killing his children or sexually abusing them because of Klinefelter syndrome? That never happens. So, if a woman is more likely to receive a manslaughter sentence than a man who would be convicted of first-degree murder for the same crime, this creates, by definition, an inflated appearance of guilt and predisposition to violence for the male demographic. And so, yes, I do not trust people who simply hold up crime statistics as definitive proof that demographic X is more criminal when they know damn well that things can be much more complex than that. So again, if you had to pin me down toward absolutely answering the question of whether or not men are absolutely more violent than women, I would answer that they possibly are, and maybe even that they probably are, if you limit the definition of violence to a very specific, and in my opinion, biased definition of violence. But that even if they unequivocally are more violent, this in no way justifies the very real bias and the very real tendency of our justice system to assume, on average, that an individual male is more deserving of punishment than an individual female is for committing the same crimes. In fact, the question of whether or not men are more criminal and violent than women completely leaves out the fact that women, as the majority of the electorate, are more likely to vote for policies that assume criminality of men and more likely to vote for policies that diminish crimes committed by women. And that, in and of itself, is an act of violence on the part of women that will never be included in some FBI crime statistics. So, what are some examples of this? We've all seen over the years that feminists have slowly morphed the definition of rape to include having sex with a woman if she's intoxicated, even if both parties consent and the man is just as intoxicated. They've also fought to reclassify the definition of rape to at least partially exclude certain types of rape against men. And when that happens, I don't care what your crime statistics say, we don't know if men are inherently more criminal or violent because the legal system furnishes an artificial result. The United States has a long history of creating laws that ensure criminality among demographics it wants to target. This is beyond the scope of this video, but I will, in my book, go into extensive detail about how this is done today and how this has been done throughout history and how it very often is leveraged as a tool to create criminal underclasses out of innocent demographics, sometimes overnight, for political and financial gain. Even right now, there exist so many laws on the books that literally anybody could be considered a criminal if the government wants it bad enough. Not only that, but the fact is that the government has a history of creating conditions in which a certain demographic will inevitably commit more crimes because those policies target the unique conditions that demographic is more likely to face. And the beginnings of this, harken back to post-bellum vagrancy laws that criminalized unemployment for black males. Now, if you study this period in American history and compare it to our current state of affairs, you will see many parallels between that and the way men and men only can be thrown in jail for example, lack of child support payment. Are they the same? No, of course not. But they are similar and differ only in degree, not in nature. The idea is to criminalize men and to, in doing so, steal their labor in the prison systems, amongst other things. But to be clear, I'll spell it out. The government, in certain instances, has made it a criminal act to, as a man, impregnate a woman and then, due to circumstances that may be completely out of your control, like a job loss or disability, if you can't keep up payment to support that child, you can be thrown in jail. Simultaneously, the government has also made a host of programs to ensure that women who can't make enough money to care for their offspring are given government subsidies and welfare and not thrown in prison. In this act, the government has, by definition, endeavored to create male criminals out of thin air. It's truly that simple. So yes, on paper, devoid of context, men can certainly be considered more criminal than women, but with context, we see that the government in certain situations has quite literally rigged the system to guarantee increased male criminality. Saying that men are more likely to be homeless is not the same, for example, as saying that women are better at avoiding homelessness than men are. There are, of course, a whole host of government programs to help them avoid homelessness, and the same is the case with crime and punishment. Texas is a state where if you have 6 months of back child support, you can legally be barred from renewing your vehicle registration. So think about that one for a second. We all know that women get custody of children the vast majority of times in child custody disputes. We all know the recession hit male-dominated fields of employment particularly hard. The average time a person remains unemployed is about 25 weeks or just under 6 months. How is this not guaranteed to create male criminals and increase crime done by men? Let's say you lose your job, you take 6 months or more looking for another job. You're male, so you're less likely to have custody of your children. Once you've passed the 6-month mark, the government prohibits you from renewing your vehicle registration, which means you're even less likely to find a job. And because of that, you're now more likely to turn to crime to provide for yourself. Since you're more likely to resort to crime, you're more likely to go to jail. And again, this is in Texas, a state with one of the highest amount of percentage of prisoners housed in private, for-profit prisons where they can pay you 10 cents an hour for your labor. And once you get out, your criminal record further prevents you from finding gainful employment. It's a vicious cycle of economic exploitation. And although on paper, the law says, all parents, including mothers, are subject to these laws, the fact that women get custody over 90% of the time means that this is writ large an economically predatory law against men. Another example, men of all races are more likely to both use and sell drugs. So a crime that, in my opinion, should be absolutely legal and should not be criminalized whatsoever, has created an entire industry that both creates mostly male criminals and increases recidivism. Now, I know it's difficult to accept that when the government makes a good illicit, in which the demand for that good is very high, they are in effect creating criminals. And I know because drugs have been considered illicit for, most of our lifetimes, and most of us are so far removed from the days of prohibition, It just doesn't register to us how alcohol's prohibition, for example, or drugs prohibition caused the rise of a mostly male criminal underclass. But a modern day example is the Canadian government's forced partial nationalization of maple syrup and how it has led to maple harvesters committing acts of arson, burning down government federation barns of maple syrup after the government enforced quotas and started seizing maple syrup from all maple syrup farmers who didn't adhere to their price and supply control regulations. Now, it's a fascinating little lesson in the economics of both the creation of black markets and the proliferation of criminality and violence that follows them. And I may actually make a video on that topic alone by itself, but that's for another time. So now that we see that the overall attitude society has toward male crime versus female crime is very different, and society is very willing to exercise extreme and in some cases unofficial, but publicly sanctioned punishment, and even capital punishment against men, now that we see that society is willing to rejoice in the rape and suicide of men in the prison systems, we can begin to understand why and how this factors into the administration of the death penalty. I want to first ask the question of whether or not the death penalty deters crime. It is, after all, an important question to ask. But I'm not going to answer that question right now. After much research, I can only give an inconclusive answer, while also stating that I certainly lean toward the belief that it does not. It is a fact that in states where the death penalty exists as punishment for capital crimes, many have higher murder rates and overall crime rates than states where the death penalty has been abolished. I will say that I've seen more evidence than I have seen to the contrary that people are less likely to commit a crime if you increase the chance of them getting caught, as opposed to increasing the harshness of the penalty. So if you increase police presence or increase the visibility of surveillance cameras, etc., people are more likely to think twice before committing a crime than if you institute harsher penalties for that crime. But despite this, I do believe that one of the more insidious forms of misandry takes the form of capital punishment. The premeditated taking of human life as payment for crimes committed against society has existed with us since time immemorial. And I would imagine that in the prehistory of our species, our ancestors would happen upon a group of rival men committing some unforgivable offense, perhaps stealing some of their food or raping one of their women or killing one of the useful men that could be used for hunting or making war against rival tribes. And these offenses represented a direct threat to the survival of the tribe. And in the context of prehistory, perhaps, the deterrent effect generated by the execution of the offending parties may have perhaps, in the context of prehistory, have been justified. But back then, we didn't yet have systems of law and justice. These were advents of the state, and states didn't exist. Thus, we were relegated to tribal vigilante justice. In a modern, civilized society, however, I make the argument that the death penalty is not only unnecessary, but unethical. I think it is necessary to understand the function of a modern society and civilization. The goal is to provide a reasonable amount of security, balanced with a reasonable amount of freedom. And that is what a successful society does. It gives us enough freedom and volunteerism to facilitate the generation of wealth and prosperity that the state can then skim some off the top by taxing its productive citizenry. The state is also responsible for providing a relatively safe and secure environment for doing so. Every state is tasked with walking the balance between letting its citizenry do what it wants, at risk of causing destabilization or chaos, and crime and uncertainty, as well as stepping in when the freedom given to the citizenry threatens to destabilize the state apparatus itself. So this is the textbook struggle between liberty and security that every state must manage, and the inspiration for such famous quotes as Benjamin Franklin stating that, quote, "Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety." And this quote, while often used to make the argument that the citizenry should give up no liberty in return for safety, makes a distinction and uses the language of, quote, essential liberty. So what essential liberty means is up for interpretation, but I believe that it is meant to mean that Franklin realized that there exists certain civil freedoms that, if infringed upon, precipitate the loss of freedom overall, as well as certain lesser freedoms that in times of great peril, a citizenry can go without. The parsing out of which freedoms these are and aren't is beyond the scope of this video, but I'm convinced that the Founding Fathers understood that we should live in a society that knows that the freedoms of its citizenry are extremely important, but ultimately useless, if we do not have a safe, secure, and prosperous civilization or nation to express them in. Thus, security is almost as important as essential freedoms, but ultimately, I believe, not as important. There is a hierarchy there. So that means that there are several concepts that should be cherished, even if holding them as sacrosanct concepts makes us ultimately less secure. Thus, while it's possible that the death penalty does not deter crime, I will also play the devil's advocate and argue that even if we can prove that it ultimately does deter violent crime, it is still not worth carrying out, because there is an essential liberty that is being infringed upon that undermines the entire concept of freedom as we know it, and that is that a society that allows the execution of one of its members, while knowing that they can never be proven to be guilty with absolute certainty, is a society motivated by the same fear that led other societies to sacrifice virgins so that their crops would grow. It is a society that is governed by fear of itself, not by its principles, or an ever-increasing attempt at having a freer society. And so, yes, to be clear, I will make the argument that even if we proceed from the premise that the death penalty causes less crime, the, in my opinion, small amount of less crime we will enjoy is not sufficient to compensate for the amount of freedom we have sacrificed every time someone is posthumously proven innocent after the state has strapped them down on a gurney and premeditatedly killed them, which is, of course, an act of violence itself. I will also make the argument here that even when death row inmates who are indisputably guilty are executed, it is still an injustice unless all other inmates who commit similar crimes are also executed. And the reason for my being a death penalty abolitionist is again not solely grounded in the inevitable execution of innocents. It is also grounded in the fact that some who are guilty are executed more often than others for immutable characteristics. To kill one guilty individual and spare another equally guilty individual in service to our inherent prejudices is the height of injustice, disenfranchisement, and selective enforcement of the ultimate punishment. No citizen of a just society should stand a higher chance of being put to death for crimes than any other citizen simply for being born with the wrong, immutable, and irrelevant characteristics. For both the innocent and the guilty, the death penalty fails in regards to impartiality. Fortunately, for the sake of my argument, there exists a wealth of examples that show just how much of an uneven and impartial endeavor capital punishment in America has become. I want to take the case of Christopher Young, who was executed in Texas at the age of 34. Now, I will not try to sugarcoat what this man did. He murdered a convenience store owner, his name was Hasmukh Patel, in a drunken robbery attempt. He killed a man and a father in cold blood. The fact that he was intoxicated when he did this was, of course, no excuse. The man is guilty, he's admitted as such, and he took human life with malicious intent. He is a murderer, plain and simple. He was convicted of this crime and sentenced to death and was executed on July 17th, 2018. Now, before Young's execution, Patel's son, Mitesh Patel, had done several interviews expressing his desire for clemency for Christopher Young, the man who again murdered his father, and he's stated as saying, quote, "The biggest thing that drove me to change was that Young is actively involved in his daughter's visits. He's trying to be a good father, and being a father myself and having lost a father, I don't want someone to go through life without a father," end quote. So again, this is what the victim's son said about Christopher Young. And you know, there are videos of Christopher Young's daughter crying about the impending death of her father. And, you know, it's pretty sad to watch, you know. And when watching these types of videos, where both the family of the victim and the family of the perpetrator do not want the execution to happen, I often ask myself, you know, what did we accomplish in this man's execution? Did we bring back Hasmukh Patel? Of course not. Did we provide closure to the family members of Hasmukh Patel? No, in fact, we executed Christopher Young against the wishes of the family of Hesmukh Patel. Did we damage a young adolescent girl? Well, yeah, of course. We have a teenage girl who had to endure the loss of her father unnecessarily, and it will likely lead to a host of psychological problems and trauma for this girl that will follow her the rest of her life. So, should we be proud of this? Is this justice? Yeah, certainly doesn't feel like justice to me. It seemed like the execution of Christopher Young only created more suffering, death, and sadness for all of the parties involved. But maybe you disagree with me, and maybe you think it was a just execution. And in response to that, I would then like to cite this article from 1996 on the capital murder case of Guinevere Garcia. Now, unfortunately, this article is very long, but I couldn't really find a good way of condensing it, so I'm going to read it almost in full and then comment on it afterwards, so please just bear with me here. Shortly before 10 a.m. today, Guinevere A. Garcia was told that her long fight to be put to death was over. The governor of Illinois, acting hours before Mrs. Garcia's scheduled execution for the 1991 murder of her husband, commuted her sentence to life in prison without the possibility of parole. For months, Miss Garcia, a troubled woman of 37, had resisted every effort by death penalty opponents from around the country to save her life, which had been tormented by incest, rape, battering, alcoholism, and depression. She waived her rights to appeal and told friends that she would rather die than spend the rest of her days in prison. But Governor Jim Edgar, a moderate Republican who in 5 years at the State House had never before granted clemency to a death row prisoner, said in his message commuting her sentence today that her crime had not been, quote, among the worst of the worst, end quote. Indeed, the governor said that the evidence indicates that Miss Garcia never planned to kill her husband. Miss Garcia, who would have been only the second woman executed in the United States since the Supreme Court 20 years ago allowed the resumption of capital punishment, was informed of the governor's decision in her 6-by-8-foot cell on death row at the Dwight Correctional Center, 60 miles southwest of Chicago. Despite her earlier efforts to die, she was apparently relieved. Thank God this happened, she was quoted as saying by her lawyer Manos Kavadias, who only days ago, following her instruction, had been fighting for her execution to proceed. She hasn't slept in a couple days, Mr. Kavadias said. She's drained and exhausted. I don't know if her relief was more pointed toward the fact that she won't be dead tonight at 12:30, or that she will never die as a result of an execution. This woman thought she'd be dead by tonight. How would any of us react? Miss Garcia was to have been executed by injection. She had already requested her last meal of deep dish pizza and had given away all her possessions to friends and the 4 other women on Illinois death row. In letters to the United States Supreme Court and to Governor Edgar, she had asked that any pleas to spare her be ignored. At a clemency hearing in Springfield last Thursday, her unwelcome advocates were told in a tape-recorded message to stay out of her case. But they continued their efforts and were still faxing appeals for mercy to the governor when his decision was announced this morning. That decision was a rare victory for death penalty opponents, who said that they hoped that Mr. Edgar's action would be repeated by other governors, and last year there were 56 executions in the United States, 5 of them in Illinois, and every request for clemency was denied. The movement is incredibly overwhelmed with the numbers of cases right now, said Kika Matos of the NAACP Legal Defense Fund Capital Punishment Project. But this is great news and somewhat unexpected given the political climate. I'm stunned and speechless and very happy. If Mr. Edgar's decision ran contrary to one trend, it fit with another, the American practice of generally sparing women the death penalty. The last woman executed in the United States was Velma Barfield, age 54, who was put to death in North Carolina 12 years ago for poisoning her boyfriend. The last execution of a woman in Illinois was more than 50 years ago. Still, it had looked as if Miss Garcia would get her wish to die. Mr. Edgar, who as a state legislator voted in the 1970s to reinstate capital punishment in Illinois, took office as governor in 1991, and in the 5 years since had denied all 6 appeals for mercy sent to him from death row. Not surprisingly, all the rest of those death row refusals for clemency were all men. I think that gender had a really big role to play in this, Mrs. Matos said. We just don't execute women in this country. but it's great to see someone with the political courage to do the right thing. Governor Edgar, however, said that neither Mrs. Garcia's sex nor her bleak past was the reason for his decision. Rather, he said, he concluded that, quote, "This is not the kind of case I had in mind when I voted as a legislator to restore the death penalty," end quote. And that, quote, "It is also not the kind of case that typically results in death sentence in Illinois," end quote. Mr. Edgar said that the evidence suggests that Miss Garcia did not, quote, "have murder on her mind," end quote, when in 1991 she went to the home of her estranged husband, George Garcia, nearly 30 years her senior, who was a client of hers when she worked as a prostitute, and, court papers say, battered her after they married. The evidence indicates, Mr. Edgar said, that Miss Garcia intended to use a gun only to get money from her husband, and that he was shot to death after a fight that lasted less than a minute. Mr. Cavadias, Mrs. Garcia's lawyer, said she carried the gun that day because she was afraid of her husband, quote, "who had done everything to her except shoot her," quote. This is not Miss Garcia's first imprisonment, and this is the important part I want you guys to really focus on here. She served 10 years for smothering her 11-month-old daughter in 1977. Court records say Miss Garcia had been repeatedly raped by an uncle beginning at the age of 6, and she has said she had killed her child to save the girl from him after he threatened to gain custody of her, end quote. So, let's unpack this then. Now, when I comment on this, remember the case of Christopher Young I just mentioned. Keep that in mind. So, here we have a woman who killed her husband in cold blood, and almost 2 decades prior had smothered her own 11-month-old infant daughter. In both cases, she supposedly claimed that it was to do it to either save herself or her daughter from sexual or physical abuse. Now, I want the proponents of the death penalty listening to this to tell me exactly whom deserve to die in these cases. The man who murdered a convenience store owner in cold blood in the process of an attempted robbery, or the woman who murdered her husband in cold blood, also supposedly in the process of an attempted robbery, but whom also smothered a defenseless infant 20 years prior. One got the death penalty, that is, Christopher Young, for killing someone in much the same way the other killed her husband, but one had previously killed and the other had not. Yet the governor decided that hers was not the, quote, typical case for which the death penalty should be applied. Isn't that interesting? The question goes without saying, but would Christopher Young have gotten the death penalty had he been a woman? And that begs the question, why is it up to the illogical and oftentimes gynocentric whims of a governor to decide that one killer should be given clemency and the other not? Are we really to believe that some of these governors are not granting clemency in a biased and gendered way? So again, the inevitable argument that gets thrown in your face when you try to advocate for abolishing the death penalty is that, you're going against the wishes of the victim's family. But we have to first understand that the death penalty does not, if one looks at it as accurately as possible, function as a means of providing a form of closure or retribution for the families of the victims. What never seems to be discussed, again, are the victims' rights of the family members of the victims of murder by the state who did not commit the crime that sentenced them to death in the first place. Those families and those victims' rights never get any say. Whenever you see death penalty cases, the victims, or in the case of a murder trial, the families of the victims, which of course are still technically victims, are allowed to make, victim impact statements, which are designed first and foremost to sway the jury on an emotional basis. They serve no actual evidentiary or judiciary purpose other than to help emotionally manipulate the jurors into a conviction, or the prosecution into pursuing harsher charges after a conviction has been reached. So it speaks volumes that we are allowed to have these victim impact statements to take a life, but as the family of Hasmukh Patel demonstrates, we aren't really allowed to have them to save one. Thus, the sanctimonious desire to call for capital punishment in the name of the, quote, victims needs to be examined. Because as we see with the case of the family of Hasmukh Patel, who explicitly didn't want to have Christopher Young executed, the execution went forward. This indicates, in my opinion, that there is a repressed sort of bloodlust at play here. We are very willing to ignore the pleas of victims when it interferes with our desire to premeditatedly take another human life. And we really aren't trying to hear anything about, the way our current system will inevitably lead us to take innocent human lives. Those are victims too. They're just ignored victims. We live in a society where if you help a terminally ill relative to commit suicide to end their suffering and pain,
you can potentially be prosecuted. And if you wish to take your own life under these same circumstances, well, good luck getting access to what you need to do it quickly and painlessly without the government interfering. But the government, ironically, reserves the right to kill others, even when the family members of their victims don't wish it to happen. Isn't that interesting? And I really think that it speaks to the fact that we, for example, revere and reward soldiers for their supposed sacrifice, the sacrifice of being willing to take a life to ostensibly save others. But we don't have the same reverence for, nuclear plant physicists or people who work other very dangerous jobs that save lives every day, right? We are very willing to get all emotional about the taking of life, but never about the preservation of it. We do not wish to confront the fact that our justice system is flawed, because we wish to remain under the conception that we will never be unjustly victimized by it. And therefore, we are reluctant to fight for the rights of the wrongly accused. We cannot empathize with a group of people we are terrified of becoming, and thus we cannot empathize with a person on death row who is wrongfully accused. Because of this, we allow a system in which we not only do nothing about addressing the issues of acquiring justice for the wrongly accused and preventing more false accusations from happening, but we allow a system that simply has no idea how pervasive the issue of wrong accusations is or isn't. Deep down, those who are for capital punishment are acknowledging that they are for the eventual murder of innocent people because it helps to maintain relative order. We all know that the death penalty is going to send innocent people to their deaths at one point or another. We also know that some who are guilty will get the death penalty more than others who are guilty of the same crimes. We know this because it has happened, and we know this because, of course, no judiciary system can ever be 100% accurate. And again, are there people who are so vile and heinous that they deserve to just be put down? Probably, yeah. Probably. There are people who torture and murder children, right? And of course, these people are the scum of the earth. And in a justice system that could ascertain the truth perfectly and hand down punishment completely fairly, then the death penalty may be appropriate, but we are far from it and will likely never have that. And of course, we need to understand that oftentimes the worst of the worst violent offenders, the people who sexually abuse and murder children, are people who in their early childhood were themselves horrifically treated, were themselves sexually abused. So are we going to send the monsters who helped create these monsters to the gallows too? Do they not bear some of the responsibility? Nah, that's too much to think about. So let's just pretend that all of these people are subhuman monsters and that they were that way since birth, instead of being helped along the way by other vile and reprehensible people. There is a reason that whenever state-sanctioned mass genocides occur throughout history, there is a buildup to dehumanize the target population. They are portrayed as animalistic or vermin-like or evil or vile or pestilent because when human beings get ready to kill each other in mass, they must first turn a subconscious switch off in their brains that extends empathy to their fellow man. And this is a perfect example of how human beings can take conscious action in order to furnish a subconscious change in their perceptions. After a critical point has been reached, one group of humanity, through repetition and propaganda, is no longer able to see the other group as human just like them, and after that, all bets are off. So, of course, our society has a need to correct and prevent rape and murder, and thus, over and over, we re-demonize murderers and rapists by sheer repetition until they, or I should say, those we perceive as such, are no longer human. And again, this isn't a defense of the act. This is saying that we have to remember that we all know deep down that many people in jail for rape or on death row for murder are actually innocent. We know there must be somewhere innocent people being raped themselves or murdered by other prisoners or the state. And these are the people we have to dehumanize for our own safety. These are the people that we cannot extend empathy to, because to do so would shatter the perceived luxury of safety and security we all enjoy. Therefore, people unjustly put on death row cannot be us, and this is why I say that we re-demonize rapists and murderers over and over again until anyone even accused of rape or murder is no longer human and no longer deserving of empathy. And that's how it works. Of course, there are real murderers and rapists in jail, of course. But that instinct that we have to, oh, I can't wait till he gets to jail so he can be raped or murdered himself, that instinct leads to us turning off our empathy switch and ignoring the fact that we know that there are innocents in there that didn't commit the crime. And just the general fact that, a civilized society seeks justice and not vengeance. Look at any YouTube or Facebook comment section of someone even just accused of a heinous crime. The majority of commentators have their mind made up. A few particularly angry individuals openly gloat about the various medieval torture methods they would use on the accused if society only gave them 10 minutes of uninterrupted time with them in a room alone. When all people who are even accused of heinous crimes are guilty, because we've subconsciously hit the empathy off switch through conscious conditioning, we don't have to bother trying to ascertain the facts, and thus we leave it to our judicial system and prosecutors to take care of it, who are oftentimes equally or even more biased than we are. It has been well known for decades that there is a gender bias in the implementation of capital punishment, in which it is highly skewed toward the preservation of female life and the elimination of male life. And in order to properly convey the origins of this bias, I think it appropriate to cite the memoirs of the warden of the famous San Quentin State Prison between the years of 1940 and 1952. Clinton T. Duffy was the warden there and presided over 90 executions and detailed it in his memoir, 88 Men and 2 Women. And I'm probably going to do a separate video on just this book alone because it's absolutely fascinating. And in this book, he wrote about the first execution of a woman, Ethel Spinelli, in San Quentin and in California, and how it was attempted to be prevented by male prisoners on death row who volunteered to go to the gas chamber in her stead because it would, quote, be a moral stain on California to execute its first women. And the relevant text reads as follows. I'll read you the little clip. It says, quote, a lengthy document, it said, among other things, that Miss Spinelli's execution would be repulsive to the people of California, that no woman in her right mind could commit the crime charged to her, that the execution of a woman would hurt California in the eyes of the world, that both law and the will of the people were against the execution, and that Miss Spinelli, as the mother of 3 children, should have special consideration, and that California's proud record of never having executed a woman should not be spoiled. And remember, some of these male death row prisoners actually volunteered to go instead of her. Duffy did say that, only a minority of prisoners felt that way. But even still, this should give you an idea of the extreme lengths that men will sometimes go to protect women from the death penalty. Do you think judges aren't this biased? Do you think prosecutors aren't this gynocentric? Name me one, even a single instance, of women on death row organizing to die in a man's stead because the killing of a man would, quote, hurt California or any other state's image. Show me any instance where men get even the consideration of clemency simply for having children. Show me anyone saying that nobody in their right mind could commit the crimes of death row inmates simply because they are a man. These are things you will never see because, to be frank, there is no desire to empathize with male criminals and murderers, but there absolutely is for women. This is not simply me saying this is a verifiable fact. A gender and even racial bias absolutely does exist. The fact is that the cases of capital crimes most likely to end in the death penalty are cases where the perpetrator is a black male and the victim is a white female. And the cases least likely to conclude in a death penalty are cases where the perpetrator is a white female and the victim is a black male. Now, admittedly, this disparity is not simply having to do with the race or gender of the victims and defendants, since, of course, individuals of different races and genders, on average, tend to commit capital crimes differently. This is not to say that this justifies the bias, however, since the punishment handed out seems to depend on what is, in my opinion, really quite subjective criteria. A Cornell study titled Victim Gender and the Death Penalty demonstrates this pretty well when they discuss the reasons why certain juries perceive female victims and female perpetrators as more innocent than male victims and male perpetrators. And it says, quote, jury research indicates that jurors are deeply concerned with the character of crime. Indeed, interviews with South Carolina capital jurors revealed that the topic of the victim's character and the victim's role or responsibility in the crime were frequent topics of discussion during deliberations. Just as juries are influenced by empathy towards a victim, juries are also likely to be persuaded by their perceptions that the victim engaged in reckless or unsavory behavior. In general, juries are less likely to impose a death sentence when the victim is perceived as being too careless. When jurors see the victim's behavior as reckless, They see the crime as less appalling and less deserving of the death penalty. And this may occur whether the victim has in fact taken more risks or the jury only assumes the victim has taken more risks. That's important. Jurors may assume that female victims are less likely to be risk takers and to place themselves in harm's way intentionally, and are therefore less blameworthy for their victimization. End quote. So we see here an excellent example of how subconscious bias and not any conscious behavior can lead to a jury condemning a defendant to death, not because of what the victim did necessarily, but because of what they perceived the victim to be more likely to have done. We all know that our society views women as less likely to take risks than men. In fact, one of the few instances in which businesses are currently allowed to discriminate against its customers in America are car insurance premiums, in which insurance companies are allowed to charge more if you're a male driver, and ostensibly it may seem true that female drivers take less risk, and thus are less responsible for car accidents as a whole. But if that were truly the case, why are almost all hazmat drivers male? Why are almost all people who drive unwieldy, top-heavy vehicles that can cause catastrophic accidents mostly male? It could very well be that men are more competent drivers and thus expected to perform competently driving in environments that are more dangerous than women are usually expected to drive in. And likewise, it is overlooked, in my opinion, that female victims don't necessarily take less risks than male victims, but our society is such that men have no choice because society provides them with less of a safety net. The study continues saying, when female victims actually violate the, quote, vulnerable victim stereotype by engaging in risky or other unsavory behavior, observers may distance themselves from the victim. Female criminals who are considered to be, quote, bad and unfeminine are no longer seen to be in need of protection. Furthermore, female victims who participate in a risky activity defy the stereotype of an innocent, vulnerable female, and this may lessen the sentencer's urge to punish the defendant. In contrast, when a female victim does not visibly participate in disreputable behavior, the chivalrous justice system may defend a stereotypically innocent female victim by sentencing the defendant to death. And further down it says, another factor that may impact sympathetic perception of the victim is the relationship between the victim and the defendant. Using data from reviews of capital murder cases in North Carolina, Emmy Stauffer and her colleagues found that a previous relationship between the victim and the defendant decreased the likelihood of a death sentence. According to their data, defendants who murdered female strangers were significantly more likely to be sentenced to death, suggesting that a relationship with a victim weighs against the imposition of the ultimate punishment. Female victims may appear to be more responsible for their death if they know the offender well. End quote. And that part, I think, is key, because it illustrates that certain crimes are simply considered to be worse, although they may in fact not be. And it also explains part of the female factor of leniency being grounded more in their natural neoteny as opposed to their, quote, femaleness. Women, for lack of a better word, of ill repute, or, butch, ugly women like Aileen Wuornos, do not have the natural neotenous traits that confer the appearance of innocence, and perhaps this increases their likelihood of receiving the death penalty. And this also mentions the fact that if a victim is known to the defendant, they appear more innocent to the jury, and since women are more likely to kill loved ones and men are more likely to kill strangers, this again functions as a subjective, nebulous criteria for who should die that will disproportionately target men. Is there any reason that murdering a stranger is more deserving of capital punishment than murdering a loved one? Is the loved one any less dead than the stranger? Is the fact that women are more likely to murder children not equally as bad as men being more likely to murder a stranger? Are we saying that the life of an adult stranger is more important than the lives of children? Or are we saying that the lives of children are worth less when their mother kills them? Or that the life of a human being is worth more if they are killed by someone they don't know? Who makes this decision? They seem to me to be extremely irrational conclusions based on primal human emotions and have no place deciding who gets to live or die for capital crimes. And I'll just read some more statistics from the study. It says, Figure 1 reveals that the death penalty was sought most in cases with white victims and least in cases with black victims. The female victim, this is interesting, the female victim effect is strongest for black victims. During the relevant time period, nearly a quarter of the Delaware homicides with white victims of either gender resulted in capital trial that reached the penalty phase. In contrast, 18.07% of cases with black female victims and just 10.51% of cases with black male victims led to a capital trial that reached the penalty phase. Thus, considering the overall pattern of homicides in Delaware, we see that the death penalty was sought less often when the cases involved black victims of either gender, and that was especially true for cases with black male victims. Cases with white female victims resulted in capital trial with penalty phase 3 times more often than cases with black male victims. An additional analysis of the proportion of death sentences per homicides in each of the victims' race and gender groups largely confirms these patterns. The highest proportion is for homicides of white female victims, in which 11.6% of homicides resulted in a death sentence at trial, and the lowest is for homicides of black male victims, in which 2.5% of the homicides led to a death sentence at trial. The proportions for homicides of white males, 8.7%, and homicides of black females, 8.4%, fell in between. Now keep in mind, the study does go on to say that there is in fact a difference by race and gender for how the murders took place, stating, quote, "Victim gender was also associated with the method of the murder and the relationship between the victim and the defendant. Figure 3 shows that female victims were far more likely to be killed by a paramour than male victims. In addition, male victims were far more likely than female victims to be killed by a firearm. Female victims were more likely to be killed in a method in the, quote, other category, which includes methods used in only a small number of cases, including suffocation, poison, and being struck by a car. These rare methods were used more in murdering women. Other characteristics of male and female victims may also play a role in the female victim effect. The characteristics of male and female murder victims differed along 3 dimensions. Male victims were less likely than female victims to have family responsibilities. Male victims were also more likely to be involved in disreputable activity, such as being grossly intoxicated at the time of the crime, or participating in a shootout with the defendant. Female victims also ranked higher on the vulnerable victim scale, which assessed dimensions of the cases that put the victim in an especially defenseless position. So, again, there are some important distinctions to be made here. Certainly, despite my being an abolitionist, I can absolutely understand why male victims are given less empathy if they take part in a shootout with the defendant. But we also see here that a factor that contributes to male victims being seen with less empathy, and thus their killers being least likely to get the death penalty, is the fact that they are less likely to have, quote, family responsibilities. And this speaks to exactly what I'm talking about, where the state creates laws that furnish results in which a demographic will receive harsher punishment for crimes committed. The state has deemed it appropriate to award custody of children to women in over 90% of custody dispute cases, and this undoubtedly leads to women having more familial responsibilities. The state quite literally fashions it that way. So while this study definitely includes data that can make you say, okay, I see where in this instance men get the death penalty at a higher rate, it also has clear examples of institutionalized ways in which the state makes a higher rate of death row sentences for men a foregone conclusion and less harsh punishment for women who commit the same crimes another foregone conclusion. And these instances tend to arise from subconscious bias, which is why, in my opinion, it is not just to take the life of a human being convicted of capital crimes. Now, we're discussing general juror bias here, but it's important to look at not only juror behavior, but juror makeup as well, and how juror striking is used to pad the jury with demographics that are more likely to convict the defendant. Now, interestingly enough, at least some legal precedent exists that shows us how women, for example, can grasp the benefits of having a jury selection of their own peers, and by that I mean their own gender. I want to cite legal precedent here in the case of Durren v. Missouri, and a case preceding that, Hoyt v. Florida. Now, in Durren v. Missouri, which was an incredibly interesting case, and coincidentally Ruth Bader Ginsburg's last case before being appointed to the Supreme Court, Durren, who was convicted of murder, argued that his right to a fair trial delineated in the Sixth Amendment was violated because at the time, the state of Missouri gave women the right to refuse to participate in jury duty. A brief summary of the case reads as follows. Petitioner was convicted of first-degree murder and assault with intent to kill in connection with an attempted robbery of a United States Post Office in Jackson County, Missouri. The trial court denied both his pretrial motion to quash the jury panel and his post-conviction motion for a new trial. Both motions alleged that Missouri's jury selection process systematically excluded women in violation of petitioner's Sixth Amendment right to a fair trial. Missouri's constitutional jury duty provision and implementing statute allowed women to decline jury service solely on the basis of their gender. Aside from women, Missouri law also exempts doctors and nurses, lawyers and clergymen, and school teachers and persons over 65, as well as government workers from jury duty. The Missouri Supreme Court, on appeal, upheld petitioner's conviction against the Sixth Amendment challenge. The United States Supreme Court reversed and held Missouri's law allowing women to exempt themselves from jury duty on the basis of sex violates the Sixth Amendment right to a fair jury trial because the resulting jury veneris failed to reflect a fair cross-section of the community. Now, I know I'm butchering all of these legal terms, but, bear with me. So this right to forego jury duty for women seems to have a fairly recent precedent, specifically in that case I just mentioned, Hoyt v. Florida. Now, in one of the first cases to have widely publicized the battered woman syndrome defense, Gwendolyn Hoyt, who murdered her husband in retaliation for mental and physical abuse she claimed to have suffered at his hands, argued also that she was deprived of fair trial because the all-male jury who convicted her could not reasonably be considered to be a jury of her peers. Women in Florida were exempt from having to serve on juries at the time, citing the gynocentric reason that since women had a, quote, moral duty in the home, presumably doing the child rearing, they, along with doctors, nurses, government workers, etc., should have the privilege of foregoing jury duty. Furthermore, women who failed to appear for jury duty when called were automatically exempted. Thus, this woman tried to pad the jury with people whom she thought would be more sympathetic due to their shared gender. Now, I tried to actually look up if male and female jurors do display this gendered bias, and ironically, I saw evidence that it seems that having an all-female jury could in fact work against the interests of a female defendant. An article titled, quote, Female-Dominated Juries Less Likely to Convict in Rape Cases, based on the 2009 publishing of the book Rape and Justice in Ireland, shows that a study of Irish courts revealed that female jurors are less likely to convict men of sexual assault. The article states the following. Quote, the authors studied and analyzed the verdicts and gender breakdowns of 108 juries, of which 64% had more men on them than women, 17% had more women on them, and 19% were evenly divided between male and female jurors. Their study showed that female-dominated juries did not convict of rape in any case, and the male-dominated juries had a higher conviction rate. And again, all of this is going to be linked in the description box if you want to peruse them yourself. However, I want to also cite this study from an article titled, Juries with Women More Likely to Convict People of Sex Offenses, which was much more robust and contradicts the previous study I just cited. And it states, quote, conviction rates for sex offenses soared after women were allowed to sit on juries almost a century ago, according to new research. Specifically, female representation increased conviction rates in sex offense cases by 16%, despite the juries still being mainly made up of men. The same trend was seen in rape cases and other sex crimes, mainly gross indecency. It had previously been suggested men standing trial for rape are more likely to walk free if they appear before a female-dominated jury, but a 9-year study of more than 3,000 cases at the Old Bailey before and after women became eligible to serve on English juries in 1921 found this was not the case. Their addition in the early 20th century had a, quote, significant impact, particularly for cases in which women were prominent as victims or defendants, say economists. Corresponding author Professor Randy Hjalmarsson, I don't know if I'm pronouncing that correctly, of Gothenburg University in Sweden, said, quote, the magnitude of these effects is substantial, especially in light of the fact that males continued to constitute more than 80% of jurors post-reform. The law change also led to a gender gap between violent crimes in which victims were male or female. Where it was a woman, these became 20% more likely to lead to convictions compared to if it was a man. The results published in the Economic Journal showed female jurors had little overall effect on the conviction rate as a whole, but they substantially affected a subset of cases for sexual and violent crimes. They could have viewed the alleged behavior or its impact on the victim from a different perspective than their male counterparts, said the researchers. Convictions for female defendants charged with other offenses, many of which were related to abortion, were greatly reduced. So again, some conflicting information here as to whether or not having a certain gender populating a jury will improve or decrease a man's chances of getting sent to death row. But the most recent evidence I cited seems to show that women are more likely to convict men who are charged with a subset of particularly heinous sex crimes more often. And we do know that in certain cases, jury demographics have certainly led to unjust executions. I want to share with you the case of Willie Francis, whom was convicted as a minor at the age of 16, sentenced to death, and was actually electrocuted at the age of 17, but survived because an intoxicated prison guard set up the electric chair incorrectly. He was executed successfully about a year after surviving his first execution attempt at the age of 18. In 1944, Andrew Thomas, a pharmacist in St. Martinville, Louisiana, was shot and killed. His murder remained unsolved for 9 months, but in August 1945, Willie Francis was detained in Texas due to his proximity to an unrelated crime. Police claimed that he was carrying Thomas's wallet in his pocket, though no evidence of this claim was submitted during the trial. Francis initially named several others in connection with the murder, but the police dismissed these claims. A short time later, while under interrogation, Francis confessed to Thomas's murder, writing, quote, "It was a secret about me and him," end quote. He had no counsel with him, and the meaning of his statement is still uncertain. Author Gilbert King, in his book The Execution of Willie Francis, written in 2008, alludes to rumors in St. Martinville of sexual abuse of the youth by the pharmacist. Francis later directed the police to where he had disposed of the holster used to carry the murder weapon. The gun used to kill Thomas was found near the crime scene. It belonged to a deputy sheriff in St. Martinville who had once threatened to kill Thomas. The gun and the bullets recovered from the crime scene and Thomas's body disappeared from police evidence just before the trial. Despite 2 separate written confessions, Francis pleaded not guilty during his trial. The court-appointed defense attorneys offered no objections, called no witnesses, and put up no defense. The validity of Francis' confessions were not questioned by the defense, although he had no counsel at the time. 2 days after the trial began, Francis was quickly convicted of murder and was sentenced to death by 12 jurors and the judge, despite Francis having been underage at 15 at the time of the crime. As Louisiana had disenfranchised nearly all blacks at the turn of the century by its new state constitution, the jury was all white, since only voters could serve. Francis was then strapped down to the electric chair the first time at the age of 17, and due to the incompetence of an intoxicated prison guard, after the switch was thrown, Willie Francis survived the jolt of electricity that surged through his body, after which a legal challenge was taken up by a lawyer by the name of Bertrand DeBlanc, who was actually the best friend of the man Willie Francis was sentenced to death for killing. Although the trial was fraught with prosecutorial misconduct, DeBlanc argued that Francis's right against double jeopardy and cruel and unusual punishment were being violated by forcing him to go through the electric chair again. This argument was unsuccessful, and Francis was executed on the second visit to the chair at the age of 18. So, several travesties of justice happen in this case. First, there's the ethical issues surrounding the execution of a minor, the ethical issues with subjecting someone to a failed execution, and then attempting the execution successfully a second time a year later, which can, in my opinion, certainly fall under the umbrella of cruel and unusual punishment, doubly so if you consider the death penalty in general to be cruel and unusual. But the fact that at the time, Louisiana had disenfranchised most black voters, and that only those who could vote could serve on juries, played a huge part in the conviction and execution of Willie Francis, who honestly didn't come close to receiving a fair trial, and could very well have been innocent for all we know. And even if we could prove without a doubt he was guilty, he could have been guilty with mitigating circumstances that weren't properly addressed because of a biased and racially homogenous jury. And unfortunately, I think the term racialized misinjury is applicable here. Now, I don't know if there are any studies on this, but I sincerely believe that if a defendant is male and of race A, and the jury is comprised of mostly men of race B, and the victim is female and of race B, then the jury is more likely to convict and sentence to death the defendant. I know the Duke Lacrosse case is not an example of death penalty case, but I think watching this clip in which Michelle Malkin asked for an apology from a black nationalist type for his repeated insistence of the guilt of the Duke Lacrosse team members accused of raping Crystal Gayle Magnum demonstrates the concept of racial misinjury aptly here.
You're not going to apologize to the Duke lacrosse team that you smeared, that you convicted. Didn't you hear the North Carolina Attorney General's statement? Didn't you hear that they said that the evidence is that there was no attack? What exactly?
I didn't hear that. I didn't hear that. I'm a criminal defense attorney. Many clients that I've had, the cases have been dropped against them, but I can't say that nothing went wrong. What I hear is political pressure that a powerful white university with powerful rich white defendants against a poor black woman, the case has been thrown out. But Nifong didn't interview the witness and charge the case properly. Nifong didn't give exculpatory evidence to the defense. It is Nifong who botched this case. And all women who will bring sexual assault charges in the future are adversely affected by this. So the accuser is a victim here as well. No, I do not apologize. Duke University has said that this lacrosse team has been engaging in rowdy, drunken, and lewd behavior, and several of these defendants who were let off yesterday have already been convicted of criminal charges of other nature. So no,
Mr. Shabazz,
I do not apologize.
Mr. Shabazz, you and your so-called party, how many members do you have? 15? Have made a career out of stoking racial demagoguery.
Let me say this. I would much rather be a member.
Can I ask a question first,
Go right
sir?
ahead.
And last May, one of your members said to Reed Seligman, one of the Duke lacrosse players, quote, that he was a dead man walking. You're not going to apologize for that?
First of all, I can't confirm that's true. Will you apologize for being a political prostitute? For Bill O'Reilly, a white male chauvinist racist, as a woman of color?
Do you want to call me a whore on national TV?
Yes,
there's only one whore on this split screen, and it's you, Mr.
As a
Shabazz.
woman of color, you should be ashamed of yourself for being a mouthpiece.
You should be ashamed of yourself
for a
profiting off of your racial poison.
Racist Bill O'Reilly. You should be ashamed of yourself for defending and being a spokesman for Bill O'Reilly, who has no respect for women.
Notice here the insistence over and over that these men are still guilty, even though the accuser herself admitted that it was a fabrication, even though timestamps show some of the accused getting gas at the time that the attack was allegedly taking place. The man is simply too angry and blinded by his racism to admit that he was wrong, and the way he just kind of casually waves away the possibility that one of his own shouted, quote, dead man walking to one of the accused is frankly disturbing. And if this man or men like him ever sits on a jury for a capital murder case in which a white man stands accused of killing a black woman, especially with aggravating circumstances of rape before she was killed, he will vote to convict no matter what the evidence states, period, point blank. Crystal Gayle Mangum, the Duke lacrosse accuser, was, of course, later convicted of murdering her boyfriend, which would have never happened if she would have went to jail for falsely accusing these men of rape. Of course, giving her the death penalty was never even on the table, even though men have been executed for far, far less. And this phenomenon of racialized misinjury, as I like to call it, is certainly not limited to members of the new Black Panther Party. I want to revisit the Emmett Till case again in order to stress that this is a characteristic of pretty much all of these racial identity groups. I'll let you guys research this for yourselves, but when you get a chance, look up the various, the real truth about Emmett Till posts that have appeared on the internet by, white nationalist types and see how over and over they all assumed that Till was, he was really a thug, that he was really the aggressor against Carolyn Bryant and that he deserved what he got. Emmett Till was again brutally murdered by the husband of Carolyn Bryant and his friend after Bryant accused Till of flirting with and groping her in a convenience store. Decades later, Carolyn Bryant admitted that the part where she claimed Till was being sexually menacing and crude to her was made up, even if it was true, that still wouldn't have warranted being murdered by those two white knighting thugs. But most of these articles were written, before Bryant's confession, and not a single one of these white nationalist types issued a retraction or an apology for essentially saying that a 14-year-old boy was basically asking for it when he was murdered for the crime of allegedly groping and whistling at a white woman. Again, I suspect that if racial misandrists like these ever get put on a jury, and in this case you're a black man, you're simply fucked. Because there's no way that they're going to give you a fair trial. As simple as that. Now, I want to be clear that I'm not advocating any violence in any capacity here. But what are the odds that some vigilante group is now going to do anything to Carolyn Bryant for needlessly causing a 14-year-old boy to be brutally murdered for her crimes and her lies? What are the odds that she'll even face criminal prosecution? I would say slim to none. And again, therein lies the problem with the death penalty, is that even when someone admits to heinous crimes, their gender and other irrelevant factors are often what determines whether or not they will pay the ultimate price for their crimes. Now, there does exist a legal method by which lawyers can and very often do make sure that jurors that will be sympathetic to their cause are selected for a jury, and that is by exercising the peremptory challenge, which is a right in jury selection for the attorneys to reject a certain number of potential jurors without stating any reason whatsoever. And historically, prosecutors especially have benefited from this and used their challenges to strike jurors that they believe will not be swayed by their evidence. And the controversy with peremptory challenges is that in the past, in America, it had been used to furnish racially biased kangaroo courts, in which prosecutors repeatedly struck jurors over and over until they had a racially homogenous jury that was not of the same race of the defendant. Now, if you're thinking, well, how does this relate to misandry, and how does this relate to, the gender bias in the criminal justice system? And you may be asking yourself, well, how will it affect me? Well, in the past, prosecutors would use peremptory challenges to pad the jury in a racially biased manner. And I'm sure that still happens in some places still, and I'm going to show you some evidence of that. But it doesn't just happen with race. I want to cite the case of William Oberle. This was a case in 2014 in the Boston State Supreme Court, and the case went as follows, quote, "The State Supreme Court has upheld a Dedham man's conviction for kidnapping and assault and battery charges in the 2014 domestic violence case. In a ruling issued today, the Supreme Court Judicial Court said a Norfolk County Superior Court judge acted properly in the trial of William Oberle, who was indicted and convicted for abusing a woman who was living with him. Oberle appealed his conviction directly to the state Supreme Court, arguing that the trial judge was wrong to deny his peremptory challenge of a female juror and to admit, quote, bad act evidence of his first instance of abuse of the same woman 5 months earlier. The judge did not err, Justice Margot Batsford said, writing for the full court. Prosecutors and the defense can both use peremptory challenges to exclude prospective juries without explaining why those jurors are being dismissed. Oberle also argued that prosecutors lacked enough evidence for the kidnapping charge, but Batsford wrote, quote, "We are unpersuaded," and affirmed that conviction, unquote. According to the court opinion, Oberle's victim said she began a romantic relationship with Oberle in the summer of 2013, and that soon he began controlling her by keeping her from looking at or speaking to others in public. In February 2014, she went to a hospital emergency room with bruises on her face, neck, ears, and arm, and said Oberle had threatened to kill her. They reconciled and moved into his daughter's house in Dedham, but the abuse soon resumed. And it goes on and on from there. Now, was Oberle guilty? I have no idea. But this, gentlemen, is what always happens. So if you think, hey, using peremptory strikes in a racist fashion will never affect me, well, not only can it, if you or your loved ones are on trial for a racially charged crime, and prosecutors start to pad the jury with racial nationalist types of the race of the victim, you most certainly will be affected. But despite this, if you're a man and have been falsely accused of domestic violence from a woman of the same race as you very well may have a judge rejecting your peremptory strikes as a defendant if you object to having a female juror, which, as we've seen in the earlier study cited, can certainly earn you more harsh punishment and a higher likelihood of conviction. But you'll also have to worry about the prosecution padding the jury with women, maybe even politically motivated women whom think that women should be believed by default. And all of this can be done without explanation or justification, so essentially this is a perfectly legal means of circumventing due process for those who wish to. Now, I'm not saying that I'm completely against peremptory juror strikes or peremptory judge strikes. However, there should be oversight to see if strikes are being done with bias, And currently, that does exist in some courts in the US, and in other courts, there's much less oversight. And it was ruled to be unconstitutional by the Supreme Court in Batson v. Kentucky to strike jurors solely on the basis of immutable characteristics such as race and gender, and this challenge of peremptory challenges became known as the Batson Challenge. However, the language given regarding the Batson Challenge leaves a lot to be desired in terms of giving defendants anything other than protection in theory and not in practice regarding bias from peremptory challenge. And the language reads as follows. The defendant first must show that he is a member of a cognizable racial group and that the prosecutor has exercised peremptory challenges to remove from the veneer, or the jury pool, members of the defendant's race. The defendant may also rely on the fact that peremptory challenges constitute a jury selection practice that permits those to discriminate who are of a mind to discriminate. Finally, the defendant must show that such facts and any other relevant circumstances raise an inference that the prosecutor used peremptory challenges to exclude the veneer men from the petit jury on account of their race. Once the defendant makes a prima facie showing, the burden shifts to the state to come forward with a neutral explanation for challenging black jurors. And the same standard has been applied for gender and I believe sexual orientation as well. So again, are there Supreme Court rulings to protect you from the negative effects of peremptory challenges? In theory and ostensibly, yes. However, we all know that in practice, a man, let's say a lower middle class man or a blue collar man who really can't afford the best legal representation, if at all, is going to have a hell of a time in a domestic violence case against him, proving that prosecutors are padding the jury with women in order to boost the chances of a conviction against him. There is an unspoken reality that all men understand that the power lies, unfortunately, with the prosecutors and the judge and the woman in domestic violence cases against men. So in practice, there's almost nothing to stop prosecutors from simply doing it and counting on not being called out for it. And this case is the perfect example of how overt bias need not even be present to furnish a biased result that may as well have originated from some sort of prejudice. Philadelphia prosecutor Jack McMahon is a prosecutor whom, in my opinion, is not overtly racist, but so obsessed with obtaining a conviction at all costs that he may as well be, and in my opinion, he is almost certainly not an overt misandrist, but may as well be for the same reason. An hour-long video of him in 1986 was leaked with him giving advice to less experienced prosecutors on how to select juries in order to help them get convictions. And in it, he displays what can only be described as an appalling set of legal ethics that explicitly argues that certain racial and gender demographics are more likely to obtain convictions, and as such, prosecutors should selectively use peremptory strikes on those demographics more often. He argues that blacks overall are less likely to convict, but also makes several intra-racial distinctions, arguing that black men from the South are more likely to convict than black women. He also heavily implies that your best bet is a conservative man who is more likely to believe a woman despite the evidence. He even discussed the complex interplay between juries in which both black and white jurors are present, and how the exact right mix of blacks and whites are even more likely to facilitate a conviction than an all-white jury or an all-black jury. At one point, he explicitly states that it is bad to have intelligent people on the jury because they, quote, take due process too seriously. So McMahon is more of a win-at-all-cost prosecutor who doesn't care if he has to use tactics that will lend themselves to prejudice and bias, and this can often have the same exact effect as someone acting with malicious prejudice and bias. Now, I'm going to show you that video in a second, but McMahon, to my knowledge, still practices today and has represented the likes of Kermit Gosnell in his controversial murder case where he was accused of running an abortion clinic where several partial and even post-birth abortions occurred at his hand. Now, before I play the full video, keep in mind that Jack McMahon has successfully prosecuted cases in which the defendant was given a life sentence, and in 1989, defendant Harold Wilson was prosecuted by Jack McMahon in a capital murder trial and sentenced to death, and in 2005, 16 years after his conviction, DNA evidence cleared him and all of his charges were acquitted. So here we have a concrete example of a prosecutor who was so conviction obsessed that he admitted to using any means necessary to select juries that will convict, and in the process, he sentenced someone to death who was later cleared, by exculpatory DNA evidence, which of course means that we are almost certainly executing innocent people to this day because of prosecutors like this. So I'm going to play the McMahon vid now.
Up and asked me to speak on jury selection. I was thinking about it, and I said to myself, when you're talking about jury selection, that is probably the single most important part of a case. Preparation, evidence, witnesses, statements, doesn't mean anything unless you have a good jury. And I've seen more than one case, great cases, and you have a lousy jury. It doesn't make a damn bit of difference unless you have a good jury. So it is probably the single most important thing that you're going to learn to do to be a good jury lawyer, is to be able to pick good juries. And but on the other hand, it's the most important, yet it's the most unscientific. It is the most difficult to learn. It differs from case to case, and you're never going to master it.
So already at 1 minute and 10 seconds, he claims that the jury composition is the most important part of winning the case, but the least scientific, meaning it is extremely susceptible to bias and prejudice.
You don't want to, if they indicate that they're a police officer or a victim of a crime, you want to ask the questions in a fashion that's going to make them not answer it in a way that's going to get them excused for cause. In other words, the person says he's been a victim of a crime, a woman. So you don't say to the woman, you've been a victim of a crime, what was that? Robbery? Yeah? Well, what was it about? Tell us about it. Would that affect your influence? No, you'd be nice to her. You say to her, ma'am, I indicate that, and you lead her. It's you leading the witness, just as you would do in a cross-examination. This is a favorable witness to you. This is somebody that you want as a juror, so you don't start jumping on them or ask them in open-ended ways. You don't want to say to them, ma'am, would that have any effect on you? Because then she may say yes, right? And then that's not the answer you want. So what you do at that point is you say to the woman, ma'am, you indicated that you were robbed at point of knife. Now, this defendant didn't do that, of course. Now, that wouldn't have any effect on, of course, that wouldn't have any effect on your deciding whether this guy is innocent or not, or guilty, because that had nothing to do with your incident, of course, right? And she'll say, oh, then it's phrased in those ways, she feels like a jerk if she says, well, yeah, it would, yeah, it might bother me that do it. But, and then they look like foolish. So you want to put them in a situation with a juror that you like, because you're trying to minimize your using the strikes, of not letting her open-ended say, well, it might bother me or something, because you don't want those answers, because that just jumps out at the defense and then they'll go all on it. So what you want to do is you want to bring them right into you.
About 12 minutes in, he describes how you lead a female witness so that she doesn't get struck from the jury for being potentially biased for being a victim of a violent crime. And he literally says you, quote, lead the juror, and uses semantics to ask the more likely to convict female juror if her previous exposure to violence would have any bearing on her decision today, leading her to give the answer he wants.
And those are the basics, okay? That's the basics. Those are the easy parts, the basics. The case law says that the object of getting a jury is to get, and I wrote it down, I looked into cases because I had to look this up because I didn't know this was the purpose of a jury. Voir dire is to get a competent, fair, and impartial jury. Well, that's ridiculous. You're not trying to get that. Both sides are trying to get the jury most likely to do whatever they want them to do. And if you go in there, any one of you think you're going to be some noble civil libertarian and try to get jurors, well, he says he can be fair, I'll go with him. That's ridiculous. You'll lose. You'll be out of the office, you'll be doing corporate law. Because that's what will happen. You're there to win. And in order to win, and the defense is there to win too, and the only way you're going to do your best is to get jurors that are as unfair and more likely to convict than anybody else in that room. And to go with that possibility, because the defense is doing the exact same thing. So you know, you're not like, if you think that it's some noble thing, that it's some esoteric game, you're wrong and you'll lose. Like I said, you have to go in there with the idea that you want jurors who are going to be most suited to convicting this defendant. Okay? Now, what does that mean? That means that you want, as I said earlier, stable, conservative people. That's what you want. Okay? What do you do to get those type of people? Number one, I told you. You look at their married life, their background, how long they've been married, how long they've been employed. Those same things I just went through, whether they've been schooled, how long they stayed in school, all these different factors to tell you that these are stable people. Now, I'm going to tell you things that I think over the years that have come to me of doing this. And again, it's all an individual. Anybody tells you anything about trying a case and says it in dogma is wrong, because things change and it's different for every individual. But I've had fairly good success with these rules, and I think if you stay to them, you'll have fairly good success too. And that is, let's face it again, there's the blacks from the low-income areas are less likely to convict. It's just, I understand it. It's an understandable proposition. There's a resentment for law enforcement. There's a resentment for authority. And as a result, you don't want those people on your jury. And it may appear as if you're being racist or whatnot, but again, you're just being realistic. You're just trying to win the case. And the other side's doing the same thing, so to just try to be noble and esoteric is not going to work. Now,
around 37 minutes in, he straight up reads out the legal purpose of a jury, which is to get an impartial and honest verdict, and he says, well, that's ridiculous. He literally says that it's his job to get unfair jurors. He straight up says, keep black jurors off juries because they're less likely to convict. And at no point does the actual truth of the case come into his thinking. He just wants to win at all costs.
Besides the background, I've learned, and my opinion is, you don't want smart people. You do not want smart people. I wish that you could ask everyone's IQ. If you could know their IQ, you could pick a great jury all the time. You don't want smart people, because smart people will analyze the hell out of your case. They have a higher standard. They hold you up to a higher standard. They hold the courts up to a higher standard because they're intelligent people. They take those words reasonable doubt and they actually try to think about them. And you don't want those people. You don't want people that are going to think it out, and they're going to think about your case, and they're going to think, well, maybe the angle was this way, and maybe she didn't see it like that, and they're going to analyze it. You want people to come in there and say, yep, she said he did it, and that's what you want. So you want intelligent people. That's been my experience. I don't know how many juries have gotten hung up, and sometimes you have to take them. I mean, you're down to no strikes, and the guy comes in, and he's otherwise okay, so you got to take him. But they hang you up. I mean, I've seen juries out and out and out. And then besides all that, they get all hung up on the law. Then they start wanting to be, you know, Oliver Wendell Holmes now. Well, don't ever take a law student. Don't ever take a lawyer. Don't ever do that. I did it once. I'll never do it again. I tried a murder case in which the defendant, the jury, requested to see me afterwards. Now, and I walked in and there was 11 of them. I said, I know we picked 12. Where's the other guy? And they said, the juror said to me that if he didn't get out of here, we were going to kill him. And he was a lawyer. He was a lawyer, worked for, he came in well-dressed. He worked for, he's probably about 28 years old, worked for like one of the big firms in town, but he didn't do criminal work. But all of a sudden now, all his law school background came back to him, you know, and now he was going to show these people what is right. Another thing.
So at 42 minutes in, he just straight up said it. You don't want smart people on juries because they actually analyze the case and take due process seriously. I mean, what the fuck? He said you want people that say, yup, she said he did it. He did it. Literally what the feminists say. Just listen and believe. And it's really interesting that when he said that, he imagined the juror speaking in his head. And then he put on like, you know, a yokel accent and also specified gender, saying that he wants men who will, for lack of a better word, listen and believe. That should terrify every man hearing this to their very core, and it should really hit home that this is not a fucking game, and the sick laughter of the audience, these are future prosecutors in training, frankly is horrifying. And that plays to the concept of racialized gynocentrism. You know, he put on that yokel accent because he wants white, undereducated rural people that aren't really going to look into the details. He doesn't want well-read, educated whites that will actually read into the details of the case. He straight up said never to take a lawyer because lawyers may actually see the bullshit kangaroo courts he's initiating.
Real educated ones, again, this goes across the board of all races. You don't want smart people. And again, but if you're sitting down and you're going to take blacks, you want older blacks. You want older black men and women, particularly men. Older black men are very good. Guys 70, 75 years old, are very good jurors, generally speaking. So when I said, if you see a black man come in who's 72 years old and he's well-dressed and he had worked, those are great jurors. And I've seen DAs who strike them because, well, they're black, and that's kind of like a rule. Well, they're black, I got to get rid of them. But these people, in my experience, are very good jurors. I mean, they're from a different era and a different time, and they have a different respect for the law. And I've found over the years that they're very, very good jurors. Older black women, on the other hand, when you have like a black defendant who's a young boy and they can identify as his, motherly type thing, are a little bit more difficult. The men don't have that same kind of maternal instinct towards them, and they're a little bit more demanding and a little bit more law and order. The other thing is blacks from the South. Excellent. Ask where they're from. If you could tell them, if they say, well, I've lived in Philadelphia 5 years, if they're from, South Carolina and places like that, I tell you, I don't think you'll ever lose a jury with blacks from South Carolina. They're dynamite. They're dynamite. They just have a different way of living down there, a different philosophy, and they're law and order, and they're on the cop side, and those people are good. Again, I think black men are better. In my experience, black women, young black women, are very bad. There's an antagonism, I guess maybe because they're downtrodden on two respects. They got two minorities, they're women and they're blacks, and so they're downtrodden on two areas, and they somehow want to take it out on somebody, and you don't want it to be you. And so younger black women are difficult, I've found. Now, one other thing is dynamics of a jury. When you're picking a jury, you got to remember that you're picking a group. You're not picking one person to decide the case. You're picking a group that has to interact together. And that's why I'm saying you want people of all, hopefully of all the same intellectual capabilities, all middle class, same economic backgrounds, and everything. That's the ideal jury, because that's dynamically, they're cohesive. You don't want a person that's real smart, and then you don't want the real dumb ones down here, because their dynamics are not going to be there. You're not going to have some brain surgeon from Chestnut Hill with some nitwit from 33rd and Diamond. They're just not going to have any dynamics there. You know that. So you got to remember what your jury is. And again, some people say, well, the best jury is all-white jury. I don't buy that, particularly with a black defendant, because you could have reverse reaction there. I think that you need dynamics, because you don't want anybody to go back in there, because a lot of times your witnesses are going to be black, most of the time. So you don't want this all-white jury to go back there and say to themselves, who gives a shit, you know what I mean? You don't want that attitude at all. And you may get that kind of reverse racism in your case. I've always felt that a jury of like 8 whites and 4 blacks is a great jury, or 9 and 3, because then you're not going to get any of that in there. You're not going to get any of that racist type of attitude, because a white guy's not going to sit in that jury and say, didn't people live like this and that, with 3 other blacks sitting there in the room. So you got to remember you're picking a whole jury, and the jury dynamics are very important. When you pick a person, think, is he going to meld with the last person I picked?
Now, at 46 minutes in, he even goes into detail about how certain blacks that are male and from the South, are better than other blacks, black women in this case. And he goes into the ideal racial makeup of a jury being a specific interracial makeup. And now this is the perfect example of someone who's not necessarily biased or racist. I don't see this guy as inherently racist or seething with racial hatred, but he's just such a shady piece of shit lawyer that he simply doesn't care if his strategy to win at all costs ends in a way that will create bias and frankly ruin the lives of the people he's sending to jail. And remember, he's tried capital crimes and sent people to death row. And again, if you think that he won't do this just as readily on the basis of gender as he would on the basis of race, then you are, in my opinion, sorely mistaken.
Now, I'm sure you're all familiar. If we talk about the case law, I generally don't talk much about case law, but the new case is Batson versus Kentucky. I'm sure you've all become aware of that case, and I think that the policy that we should all take in that case is that, and your unit chiefs, I guess, will tell you when you get to that level, but I think the policy that we have been using is that, if for you who's not familiar with it, that's a case in which a guy was convicted of rape, I think, down in Kentucky, and he was tried by an all-white jury, and the prosecutor had struck all blacks, and and it was a racial case, and under those circumstances, they ruled that that was not due process under those circumstances. But again, you have to read Batson. It's very limited to the facts of that particular case, because you had a racial case, prosecutor struck all blacks, every black on the panel. In other words, there were 6 on the panel, and he struck all 6. And that often isn't the case here. But in the future, we're going to have to be aware of this case, and the best way to avoid any problems with it is to protect yourself. And my advice would be in that situation is, when you do have a black juror, you question them at length, and on this little sheet that you have, mark something down that you can articulate later time if something happens. Because the way the case is stated, that it's only after a prima facie showing that you're doing this that it becomes that the trial judge can then order you to then start showing why you're striking them not on racial basis. So if you do, let's say you strike 3 blacks to start with, the first 3 people, and then it's like the defense attorney makes an objection saying that you're striking blacks. Well, you're not going to be able to go back and say, oh, yeah, make something up about why he did it. Write it down right then and there. I'd write it right in my little box there, you know, and question him, say, well, he the woman had a kid about the same age as the defendant, and I thought she'd be sympathetic to him, or she's unemployed, and I just don't like unemployed people because I find they're not too stable. Any of those reasons, have them marked down in those situations, so that if the judge does come to you and say, what about it, McMahon? You could say, Judge, this is my reasons, and I have them marked down here. If he puts you into that situation. So,
and at 57 minutes in, he finishes off the video talking about how to use peremptory strikes in such a way that gives you plausible deniability and allows you to avoid a Batson challenge. And I think overall, this video really helps to illuminate the multifaceted ways in which sentencing gaps occur. You can have racial gynocentrists who are on juries, and you can have just gynocentrists who are not racist who sit on juries. You can also have prosecutors who are willing to use the bias of these types of jurors for their personal agenda and career advancement that don't necessarily have to be racist or gynocentrist themselves. Or you can have prosecutors that do have prejudice and are willing to prosecute a case in a biased manner, and you can have a combination of all of these scenarios working in tandem. So despite legal protections against most of this bias is extremely hard to prove and thus extremely hard to fight against. And this is the problem that men face, and this is why changing the laws to attempt to correct sentencing gaps such as those are only a partial solution. So this video is the tip of the iceberg. You know, the vast majority of prosecutors who think and act like this will never be stupid enough to record it on video. He's just the one idiot that did. Now I could read aloud to you the text descriptions of case after case to try to drive the point home of how the death penalty harms innocent people, but instead, I'll just read to you the case of Glenn Ford, who was the longest-serving death row inmate in the United States to be fully exonerated before his death, spending 3 decades on death row before his conviction was vacated. And then I'll show you the video of how it actually looks in real life when it's all said and done and men like this get exonerated. So I'll just read to you the case details. On November 5th, 1983, Isidore Roseman, a jeweler by trade, was found dead in his ransacked jewelry shop, having suffered a single gunshot wound to the back of his head. Ford worked for Roseman as his yardman. Ford admitted to having been present at the store that day, and a few months later, the dubious forensic opinion of a, quote, handwriting expert had made the claim that several stolen items from Roseman's store found at a local pawn shop was pawned with Ford's signature on a receipt certificate. The prosecution's star witness, a woman by the name of Marvella Brown, informed police that her boyfriend Jake, his brother Henry Robinson, and Ford were present in her home when Ford asked Jake and Henry if they would accompany him to some unspecified destination. The 3 men, according to Marvella, left together with Ford carrying a paper bag in his hand when they departed. Upon their return, Marvella said Ford was now toting a gun and in possession of a different bag, one filled with jewelry and watches. It was also claimed that Jake Robinson was also armed with a handgun. A few weeks later, based off this testimony, Ford, Jake, and his brother and another man, George Starks, were charged with the murder of Isidore Roseman, as well as conspiracy to commit armed robbery. Ford was assigned 2 attorneys by the state due to his inability to pay for a lawyer on his own. Both were selected from an alphabetical listing of lawyers from the local bar association. The lead attorney was an oil and gas lawyer who had never tried a case, criminal or civil, before a jury. The second attorney had been out of law school for only 2 years and worked at an insurance defense firm on slip and fall cases. Prosecutors were able to take advantage of the defendant's inexperience and use a peremptory challenge capacity to keep African Americans off the jury, resulting in an all-Caucasian jury with a Caucasian judge, although Ford's community was comprised of roughly 50% African American. Ford was convicted and sentenced to death by the jury without a murder weapon linking him to the crime, and with evidence from confidential informants withheld. And so Ford was then sentenced to death by electrocution in 1988, and in the year 2000, the Louisiana Supreme Court revisited Ford's claims that the prosecution suppressed potentially exculpatory evidence, and even still, 14 years after that, he was then exonerated when an unidentified informant told prosecutors that Jake Robinson admitted to killing Roseman, which prompted Ford's legal team into filing a motion to vacate his conviction and sentence in March 2014, citing, quote, credible evidence supporting a finding that Ford was neither present nor a participant in the robbery and murder of Isidore Roseman, end quote. State District Judge Ramona Emanuel overturned his conviction that same month. So again, this is an example where peremptory strikes mattered here. Unfortunately, shortly after his release, Glenn Ford was diagnosed with terminal lung cancer in 2015, and I would speculate that since prisoners, especially prisoners on death row, receive abysmal health care, Ford only really had the opportunity to see a competent doctor after he was exonerated, preventing him from catching the cancer earlier, and he died on June 29th, 2015. After his death, when Ford was no longer there to defend himself, 60 Minutes aired a program stating that Ford, despite his innocence in the murder of Roseman, was not completely without guilt, stating that, quote, Ford knew a robbery was going to take place and did not stop it, according to 60 Minutes program that aired September 4th, 2016. Further, he attempted to destroy evidence by pawning items taken in the robbery and tried to find buyers for the murder weapon used by men Ford implicated in the murder, according to Caddo Parish District Judge Catherine Durren. However, Prosecutor Marty Stroud, the prosecutor in the Ford case, stated the following, quote, that he believes Ford had an unfair trial where key evidence was suppressed by both police and prosecutors, and that Ford's lawyers did not have the financial resources nor the criminal law experience to mount a proper defense. He feels that if he had done his job properly at the time and all the evidence had been properly collected, they, quote, would not have been able to arrest Glenn Ford, let alone try him for the crime, end quote. Now, Glenn Ford was no angel. He had prior convictions for other crimes, and even if you could prove that he had some involvement, and I dispute that, handwriting analysis is notoriously unreliable and has been successfully challenged many times in many cases, so I fail to see how a, quote, handwriting analyst expert could definitively prove that Ford sold and signed these items in a pawn shop. But even if we could definitely prove this, that would only have proven that he possibly aided and abetted, not that he actually killed Roseman. And that would not be a capital offense, and prosecutors would have had to try him on perhaps second-degree murder or accessory to murder, but definitely not first-degree murder, even though that's a stretch in and of itself. But I will let you watch the confrontation between Ford and his prosecutor in the case, Marty Stroud, shortly before his death and after his exoneration.
And walked him to Glenn's front door.
Mr. Ford.
Marty, how you doing?
How are you?
Doing all right.
I've thought about this for a long, long time. I want you to know that I am very sorry. And I wish it's a stain on me that will be with me until I go to my grave. And I wasn't a very good person at all, so I apologize for that.
Right, but then it still cost me 31 years of my life and death, nothing at the end but death, because it gave me from 6 to 8 months to live.
There's nothing to say sufficient to give you those 30 years back. But I have to tell you that I've learned a lot about myself in the next 30 years, and even though this is the same person or same body, I would like to think that I've changed. And I've learned a lot from you.
You did?
I've learned watching you on television that I was thinking, man, if it had been me in there for 30 years, I'd be angry and surly.
Marty Stroud says he came here to say his piece, but did not expect anything in return.
It happened. It happened. And I'm sorry I can't forgive you. I really am. I really am.
I understand.
Okay.
I do, and I wish you well, and I wish you nothing but the best.
All right. Thank you.
Thank you. And may God bless you.
You too.
You take care of yourself, okay?
All right, you too.
Now, again, can I prove 100% that Ford was innocent? No, but really, look at that body language there. This took place, shortly before Glenn Ford's death. That certainly doesn't look like the body language of a guilty man. I want you guys to look at this so you can see the real cost of the death penalty. The wrongful conviction of a man who spent 30 years on death row and died shortly after. Marty Stroud is now a vocal opponent of the death penalty, and these are not the actions of a prosecutor who believes he did anything other than send an innocent man to death row. And Glenn Ford could not forgive Stroud for what he did, and frankly, I can't blame him for it, not one bit. But perhaps, Stroud can now stop another innocent man from going through the same ordeal, or worse, being wrongly executed if that exoneration never comes. Another case like this was the case of Curtis McCarthy, and the Innocent Project detailed his case after he spent 21 years in prison and 19 years on death row for the murder of Pamela K. Willis, a crime which he did not commit. The article reads as follows. On December 10, 1982, 18-year-old Pamela K. Willis was found murdered in the Oklahoma City home where she was staying. Willis was nude and she had been stabbed and strangled. Curtis McCarthy became a suspect because he was an acquaintance of the victim. Soon after the murder in 1983, Gilchrist compared hairs from the crime scene with McCarthy's and found that they were not similar. Police interviewed McCarthy several times over the next 3 years, but he was not arrested until 1985. At that time, Gilchrist covertly changed her notes and reversed her findings, saying now that the crime scene hairs could have been McCarthy's. Attorneys for McCarthy did not discover the change in Gilchrist's notes until 2000, when she was under investigation for fraud in other cases. At McCarthy's trial in March 1986, the prosecution relied on the testimony of Gilchrist, an Oklahoma City police chemist, who said that hairs from the crime scene could be attributed to McCarthy. Based on the hairs, Gilchrist said McCarthy was in fact at the crime scene. She also testified that McCarthy's blood type matched the blood type of sperm found on the victim's nude body. Oklahoma City District Attorney Robert H. Macy, remember that name, committed misconduct in presenting the case to the jury, withholding key evidence. The jury convicted McCarthy, and he was sentenced to death. McCarthy was on death row for 2 years before Oklahoma's highest court overturned his conviction due to prosecutorial misconduct, improper forensic procedures, and comments made on the stand by Gilchrist. McCarthy was retried in 1989 with Gilchrist again testifying for the state. The jury was again told that hairs from the crime scene could have come from McCarthy. He was again convicted and again sentenced to death. Macy, who led prosecutions against McCarthy, sent 73 people to death row during his 21-year career, more than any other prosecutor in the country. 20 of those 73 have in fact been executed. In 1995, an appellate court upheld McCarthy's conviction, but ordered a new sentencing due to a jury instruction problem in the second trial. A new jury heard 4 days of testimony in 1996 and handed down McCarthy's third death sentence. In 2000, Gilchrist was under investigation for allegedly reporting false forensic results in other cases, and that same year, she was asked to re-examine the hair evidence on appeal, and she said that it would be suitable for DNA testing. However, when defense attorneys asked her to produce the evidence, she said it had been lost or destroyed. These hairs have never been found. At the close of the investigation, Gilchrist was fired due to forensic fraud that she had committed in several cases. Her false testimony has contributed to 2 other wrongful convictions that were later overturned by DNA testing, those of Jeffrey Todd Pierce and Robert Miller. She testified in thousands of cases during her 20-year career. Attorneys for McCarthy were able to secure DNA testing in 2002 on sperm recovered from the victim's body, and test results showed that the sperm did not match McCarthy. The Innocence Project became involved in McCarthy's case in 2003 and initially consulted with post-conviction attorneys Vicky Warnecki and John Eccles. In 2005, these attorneys won a new trial after an evidentiary hearing before Judge Twyla Mason Gray, who ruled that Gilchrist's misconduct and bad faith destruction of evidence had tainted McCarthy's conviction. As the third trial was scheduled, McCarthy was represented by the Innocence Project along with attorneys Perry Hudson and Marna Franklin. In 2007, additional DNA testing showed that evidence recovered from scrapings of the victim's fingernails was from a male and did not match McCarthy. Further forensic analysis showed that a bloody footprint on the victim's body could not have been McCarthy's. Based on this exculpatory evidence, as well as the misconduct by Gilchrist, McCarthy's attorneys moved to dismiss the charges before a third trial was held, and on May 11, 2007, Judge Gray granted the motion and McCarthy was released from state custody, and prosecutors did not appeal the decision. So this case in particular shows us the type of prosecutor that seems to relish in executions and is more than willing to condemn a man to death based on flimsy evidence in order to satisfy what can only be described as his bloodlust. Robert Macy has been quoted as saying that executing an innocent person is a risk worth taking regarding sending people to death row, and keep in mind, he sent over 70 people there. Let that sink in for a second. You're telling me that a prosecutor with that kind of attitude and mentality that has been caught in engaging in prosecutorial misconduct couldn't possibly have sent one of these 70 men to death row incorrectly, or even worse, maliciously? So lastly, and I know this video is stretched on forever, but I do want to talk about the actual process of putting someone to death and the ethical concerns regarding it being a form of medical experimentation, which has its own problems. But again, since only some demographics are more likely to get the death penalty, it also represents medical experimentation on specifically those groups more often than not. So is the death penalty in fact a form of unconstitutional medical experimentation on non-consenting individuals? Because of the fact that several manufacturers in other countries who manufacture previously used chemicals to conduct executions have decided to stop supplying the US with these chemicals, the US has taken it upon itself to use untested chemical cocktails on death row inmates, causing immense suffering in many cases. And although doctors can be present at these executions, most choose not to be, in keeping with their Hippocratic oath, and thus most of these executions are conducted without a doctor present, using experimental chemical cocktails. The Nuremberg Code explicitly states that human experimentation must take place with the consent of those being experimented upon. I'm sure none of these death row inmates consent to untested chemicals that lead to botched executions being injected into them. And before lethal injection became the standard method of execution, the gas chamber and the electric chair were commonly used, leading to several botched executions as well. Some prisoners, as you heard earlier, get the electric chair twice. Some death row inmates are given reprieves at the last minute, just when the hangman was fashioning the noose over them, metaphorically speaking, or when they were just entering the gas chamber, or when the administrators were searching for a vein to inject their deadly chemical cocktail. And the psychological effects of this have the effect of mock executions, which is recognized internationally as a form of torture by the United Nations. The CIA illegally used mock executions as a torture tactic during the height of its post-9/11 hysteria on terror suspects, and they did so because they know that it causes extreme psychological trauma. And there have been numerous cases of repeated execution dates being rescheduled. The article here gives the case of Warren Hill, who was mentally retarded, and a Harvard-educated psychiatrist said the following. Stuart Gracian, a psychiatrist and former Harvard Medical School professor, said that the terror of imminent executions is more difficult for someone like Warren Hill, who is mentally retarded and has had a series of execution dates, also in Georgia. Gracian said people with mental retardation struggle with the ability to think abstractly. They have very powerful feelings, but because they have fewer cognitive strengths, they are less able to manage those feelings than others are. Hill came within hours of execution 4 times. At one time, he ate his last meal and said his goodbyes before his execution was stayed. This happened 90 minutes before the scheduled time. More recently, Hill was already sedated and strapped to the gurney when his execution was stopped with just minutes to spare. So the ethical question arises, in addition to whether or not it is ethical to premeditatedly kill people for capital crimes, if the answer to that question is yes, then the next question becomes whether or not it is ethical to prolong the wait for decades or to change the execution date once the inmate has been informed of the date of his demise, or to even botch his execution, making him endure a prolonged process of medical procedures before his life is taken. Or, and this happens more often than you'd think, making him go through the execution and setting the execution up incorrectly, causing the inmate to survive the execution, only to make him have to go through the process all over again at a later date. One of the arguments we routinely hear from those that are pro-death penalty is that the inmates do not suffer anywhere near the amount that their victims did in particularly heinous cases. And while that may be true, we must also acknowledge that these executions absolutely do cause suffering. The inmate must wait decades awaiting his execution. The inmate is at the mercy of the state's procedural methods by which they will take his life. In the United States, there has been a shortage of the chemical compounds used in the cocktail that is administered during executions because, of course, other countries refuse to provide them to the United States because they themselves have abolished the death penalty and do not want to contribute to it in America. And again, this has left the states carrying out these executions, scrambling to find new chemical cocktails, untested cocktails to be precise, with which to execute inmates. This has led to several catastrophically bad executions and execution attempts where the condemned man suffered for over an hour while the chemicals finally were able to do their work and take his life. Joseph Wood was one such man. A double murderer, Wood was sentenced to death and his execution was carried out on July 23, 2014. Wood was one of the first condemned inmates to be executed using one of the various new chemical cocktails used due to a shortage caused by countries who abolished the death penalty, withholding them. He was given the cocktail, and it was estimated that his death should have taken approximately 10 minutes. The execution did not go as planned, however, and he took an hour and 57 minutes to die. During the course of these 2 hours, he gasped for breath every 10 seconds or so, about 600 times, twisting in agony as the chemicals did their work. Another inmate, Clayton Lockett, convicted of rape and murder, was also given one of the experimental and untested cocktails. He took 43 minutes to die, at one point actually lifting his head and mumbling to himself 13 minutes into the execution. A doctor then halted the execution, but Lockett later died from cardiac arrest 30 minutes later. Now, several of the condemned have, not surprisingly, had problems with substance abuse, particularly of the intravenous kind, and as a result, when they were being executed via lethal injection, the executioners could not find a suitable vein to inject them in. This has resulted numerous times in the condemned strapped down to the gurney, while his executioners take a prolonged period of time to find a suitable vein. Such was the case with Stephen Morin, a serial killer who killed 5 women. Now, if you'll notice, I will repeatedly state the crimes that these people committed so as to not diminish what they did to their victims. That is not my goal. But Stephen Morin's veins were probed for 45 minutes while the doctors tried repeatedly to find a vein. In July 8, 1999, in Florida, Alan Lee Davis, a mass murderer who brutally killed a mother and her 2 5- and 10-year-old daughters, was executed by electrocution. And certainly his crimes were incredibly heinous. But the purpose of this video, again, is not to defend the crimes, but to reject the need for execution. And this particular execution stuck out to me because of its ghastliness and because of the commentary by members of our legal system regarding it. A deathpenaltyinfo.org article states, quote, "Before he was pronounced dead, the blood from his mouth had poured onto the collar of his white shirt, and the blood on his chest had spread about the size of a dinner plate, even oozing through the buckle holes on the leather chest strap holding him to the chair. His execution was the first in Florida's new electric chair, built especially so it could accommodate a man of Davis's size, approximately 350 pounds. Later, when another Florida death row inmate challenged the constitutionality of the electric chair, Florida Supreme Court Justice Leander Shaw commented that, quote, "The color photos of Davis depict a man who, for all appearances, was brutally tortured to death by the citizens of Florida," end quote. Justice Shaw also described the botched executions of Jesse Tefero and Pedro Medina, calling the 3 executions barbaric spectacles and acts more befitting of violent murder than a civilized state. Justice Shaw included pictures of Davis's dead body in his opinion. The execution was witnessed by Florida State Senator Ginny Brown Waite, who at first was shocked to see the blood until she realized that the blood was forming the shape of a cross and that it was a message from God saying he supported the execution. Now, if you click on the link given, you can see the pics of the cross, quote-unquote cross, formed by the blood that developed on the chest of Alan Lee Davis. I'm not going to include uncensored images of that in the video, but that last comment, especially made this execution a politicized burning at the stake with religious overtones. And again, I do not seek to minimize this man's crime. He was a mass murderer. Simple as that. But there's something just wrong about a state senator injecting religious overtones into a state-sanctioned execution. It just doesn't sit right with me for some reason. Now, wrapping things up, I do want to talk about the executioners and the witnesses to executions and how they tend to develop depression and PTSD following these executions. It is well known that executioners and people who preside over executions and witnesses of executions develop a form of PTSD. In many cases, corrections officers are randomly selected by the warden, who is responsible for ordering when the execution will ultimately happen and presiding over it. Many of these corrections officers are, just like the rest of us, people trying to make a living and get by, often not on the greatest pay. But they are required to assist with these executions. And many of these COs, they live in economically depressed rural areas. They aren't taking these jobs because they want to help kill people. They're taking these jobs because there simply aren't any other jobs available. And as a result, some of these COs that are randomly selected for the task of helping during an execution develop post-traumatic stress symptoms. 2 South Carolina COs actually filed civil lawsuits arguing that the correction facilities who made them help with these executions, despite their ethical and religious concerns, were directly responsible for their PTSD trauma. And again, I want to go back to Clinton Duffy's book, 88 Men and 2 Women. And this is an excellent book. I mean, I really want everybody to read this. But again, I'm going to do a summary of it on this channel for those of you that are interested. But this passage really stuck out to me here. He says, quote, "The cop on the beat says, all I did was arrest the man. The district attorney says, all I did was present the evidence. The jury says, all we did was review the evidence and come to our conclusion. The judge says, all I did was follow the jury's conclusion and pass the sentence in accordance with the law. The officers escorting the man to prison say, all we did was take him where the judge ordered he must go. The guards say, all we did was make sure he didn't escape. The higher court judge says, all I did was look for errors when I reviewed the case. The executioner says, all I did was throw the switch when the warden told me to. The warden says, all I did was see that the sentence was properly carried out after the governor told me there was no reason to do otherwise. And the governor says, all I did was adhere to the laws passed by the people of my state. To enforce the law should be a source of pride and satisfaction. Most men and women charged with these duties are dedicated individuals. Even though they are often grossly underpaid, they're willing to make personal sacrifices for the good of the community. I've heard many an official proudly declare after performing a brave and unselfish act, quote, I was glad to do it. It was only my job. I've never heard anyone say, quote, I was glad to take part in this execution. It was only my job. Executioners are held behind locked doors in dark, gloomy enclosures before a handful of witnesses, few of whom ever brag about what they have seen. No matter how eager their desire to watch a killer pay the penalty, their steps falter as they approach the execution chamber. Their stomachs turn at what they see there, and they can't get away fast enough after the spectacle is over. Except for a few officials, like the warden, the doctor, and the clergyman, the names of people who participated in an execution are never announced. The identity of the executioner is the most jealously protected of all, for his very title makes the flesh creep and the blood run cold. I never knew an executioner who admitted his profession to the outside world, either while he was active or after he retired. If the death penalty were right and proper, it would be carried out in public places and anyone would be free to watch it. If it were a source of pride instead of shame, the participants would be heroes and to condemn the villains they were meant to be. Instead, it's the other way around. A Carol Chessman becomes a martyr and his executioner a pariah. I told the reporters that everyone should have seen the execution of Rattlesnake James, and I wish everyone could see every execution. Put the electric chair into the information booth in Times Square, and how long would capital punishment last in New York? Put the gas chamber on the bandstand at the Golden Gate Park in San Francisco, and how long would it last in California? Line up the firing squad in front of the Tabernacle in Salt Lake City, and how long would it last in Utah? The people of a state decree the death penalty, and only the people can revoke it, but most of them are too far away from it to be interested. Unlike a fire, an accident, a dread disease, or a physical collapse, the death sentence isn't the sort of thing that might happen to a member of the family or the man next door. For the vast majority of Americans, the issue is impersonal, it never touches them, hence they rarely think about it except when a madman goes on a murderous rampage or the body of a ravished child is found. When the killer is caught, the cry for vengeance rises to a roar that subsides only when a shocked jury finds him guilty and a stern judge sentences him to death. Then everything quiets down and no one thinks any more about it, except the condemned man, a few attorneys and judges, and the people who must eventually carry out the sentence. And this passage is so powerful in my opinion because it represents a warden who presided over the execution of 90 souls, telling people flat out that if we really truly saw what the death penalty truly was in front of our faces, we wouldn't have the stomach for it. That's all I have to say for now, gentlemen. But there's probably going to be a part 2 to this because there's just so much information that I had to condense down into so little time, and it's already roughly a, 2-3 hour video. So stay tuned, gentlemen. Thanks for listening.